Okay, good morning. Today is Thursday, December 22nd, and this is the time and place for the regularly scheduled Nevada Gaming Commission meeting for the month of December. If you could please rise and join us for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Excuse me. Thank you, Madam Secretary. Has our agenda been posted in accordance with the open meeting law?
Yes, it has.
All right, at this time, I would like to remind anyone coming to the podium to speak. We ask that you speak directly into the microphone, speak as clearly as possible. Don't speak over each other, as this meeting is being transmitted electronically and being transcribed. Madam Secretary, let's proceed with our first agenda item, public comments.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters.
Anyone who wishes to address the commission may do so at this time. Matters brought to our attention during the public comment cannot be acted upon, but we are happy to hear comments of the public as well as my fellow commissioners. Comments by all will be limited to 3 minutes as a reasonable time, place, and manner restriction. If any of my fellow commissioners or myself ask questions of the public, the time needed to answer those questions will not be held against those time constraints. I'm first going to go to Carson City. Anyone wishing to make a public comment, please step forward to the podium. Anyone present there?
No one.
All right, is there anyone present here in Las Vegas that wishes to make public comment? Hi, if you could state your name for the record.
Diamante Asbury, Diamanteasberry. Good morning. I'm here on behalf of the Culinary Union. Last month, we spoke to you about Station Casino's mud lists. These were lists of Station Casino's workers prepared by management indicating which employees were pro-management, pro-union, or don't know. So MUD is an acronym where M meant management, U meant union, and D meant don't know. When rehiring workers, it is against the law to discriminate based on union preference. The company started using mud lists in 2019. Then 2 months after the COVID shutdown in 2020, the vice president and general manager of Palace Station wrote his property managers in May 2020 and said, "Our mud list needs to be updated. Regina, please apply the final version of our hourly cut list to our current and last edition of the mud list so that we can review that as soon as possible." 2 months later, the director of hotel operations at Palms Place told the corporate VP of hotel and revenue management, "Looking at the mud list, we have 13 GRAs that we would bring back. The remaining we would prefer external. 2 housemen we would bring back. The remaining we would prefer external." Station's workers were in the midst of the pandemic and financial crises, and Station was using mud lists to decide which employees to bring back. In August 2020, Boulder Station HR director wrote the property's executive team and said, "As discussed, all candidates that you and your managers wish to rehire must need to go through a vetting process before being sent for D&B. A review of your department mud list is also necessary." For what legitimate reason would Station Casinos create mud lists to keep track of employees who were pro-management and which employees were pro-union? And why would it need to review these mud lists before rehiring employees if not to discriminate based on union preference? That's illegal. Station's use of mud lists has caused damage to our community and our industry, so we are asking you again for a comprehensive investigation into this company. Thank you. And then I also have a comment from a worker who ended up not being able to make it this morning. Is it okay if I read that into the record? Okay. Very short one. Hello, my name is Dan Soranowski. I'm a banquet server at Red Rock Casino. I had worked there for 14 years before being laid off during the pandemic, then brought back on as a new hire without my seniority or benefits. I would like to wish you all happy holidays and also to remind you that my coworkers and I are still fighting for a union contract. We want to be respected at work. We are asking you to hold Station Casinos accountable for the way that workers are treated. Thank you. And where would do I hand these over there now? Okay. Thank you.
Microphone.
Okay, there being no one else to make public comment, that will close our public comment section. Madam Secretary, the next item on our agenda is the approval of the prior month's disposition.
Pursuant to NRS 241.035, this item is the consideration of the approval of the Nevada Gaming Commission disposition for November 2022.
All right, each of us has had the opportunity, I believe, to review the disposition. Are there any questions or comments? And if not, I think it's proper for a motion.
Chair, I move for approval of the prior month's disposition.
Any discussion on the motion? There being none, all in favor say aye.
Aye.
And there are none opposed. Thank you. Madam Secretary, please read in the non-restricted consent items.
Your items on the non-restricted consent agenda this morning are items 6, 7, and 10. The recommendation of the Gaming Control Board is for approval with conditions as noted on the agenda.
All right, if there are no questions or comments on any of the consent items, then I would believe it's proper time for a motion.
Madam Chair, I would move for approval of non-restricted agenda items 6, 7, and 10 as read into the record by Madam Secretary as recommended for approval by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor say aye.
Aye.
And there are none opposed. Thank you. Oh. Did you have something?
6, 7, and 10.
6, 7, and 10, correct. Okay. The record will reflect as I'm going to modify, I'm going to ask you to modify your motion, please. To 6 and 7.
Thank you, Madam Chair. Let's take, I move for approval of non-restricted consent agenda items 6 and 7 as read into the record by Madam Secretary and is approved by the Gaming Control Board.
Any discussion on 6 and 7? There being none, all in favor say aye.
Aye.
And you're good? Okay, so that's all in favor and there were none opposed. As far as a motion as to item number 10,
Subject to Commissioner Keffer's recusal, I would move for approval of non-restricted consent agenda item number 10 is read into the record by Madam Secretary and is approved by the Gaming Control Board.
any discussion? There being none, all in favor say aye. And there are none opposed, and Commissioner Keffer did not participate in the vote on this motion. Madam
Excuse me,
Secretary.
Madam Chair.
Yeah.
Could Commissioner Keffer put his recusal on the record, please?
Sure.
Thank you very much. Excuse me. Thank you, Tiffany. For the record, I need to disclose that I'm an employee of the law firm McDonald Carano. The applicant on this matter is represented by the law firm of which I'm an employee, and based on this pre-existing financial relationship, I need to recuse. Thank you.
Thank you. Madam Secretary, if you could please read in the restricted consent items.
Your items on the restricted consent agenda this morning are items 6 through 14. The recommendation of the Gaming Control Board is for approval with conditions as noted on the agenda. I believe we have a disclosure on these items.
Yes, thank you so much. I have two disclosures for restricted number 7. Dottie's is adverse in a matter where my law firm, Louis Roca, is counsel in Nevada Restaurant Services is also adverse, in which unrelated matters I am not personally involved. I have no pecuniary interest in the outcome of this agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. As to restricted item number 8, I make this disclosure in abundance of caution. An entity with a related name, Century Gaming's PTE Limited, is a client of Louis Roca, the firm where I'm a partner, in an unrelated matter in which I am not personally involved. I have no pecuniary interest in the outcome of this agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. Thank you.
Thank you. Is there any discussion or comment on these items? If not, then I think it's proper for a motion.
Thank you, Chair. I move for approval of restricted items number 6 to 14 as read into the record by Madam Secretary and as recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor say aye.
Aye.
And it appears there are none opposed. Thank you. Madam Secretary, please read in the new gaming device consent item.
You have one item on the new gaming device consent agenda. That item is running rich reels submitted by Competition Interactive LLC. The recommendation of the Gaming Control Board is for approval.
Okay, I think we're all pretty aware and comfortable with this item, but if anybody has any comments or discussion, there being none, it appears that it's proper form for a motion.
Madam Chair, I move for approval of the new gaming device running rich reels as read into the record by Madam Secretary and as recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
And there are none opposed. Thank you. All right, now we're going to have non-restricted items held out for discussion. Madam Secretary, if you could read in non-restricted number 3.
Non-restricted number 3 are the applications of BCE Technologies LLC doing business as BCE Technologies for licensure as a manufacturer and distributor and as an information service. It is also the applications of Vahagan Badalian, Bruce Murati, Armin Vardanyan, and Vahe Badalian for licensure as a member, manager, key executive, key employee, and/or lender as noted on the agenda. The recommendation of the Gaming Control Board is for approval with conditions as noted on the agenda.
Good morning, Chair Tagliati, Commissioners, Secretary Rupert. For the record, I'm Scott Scherer of Brownstein Hyatt Farber Schreck, appearing today on behalf of the applicants. With your permission, Chair Tagliati, I have prepared an affirmative presentation similar to the one presented at the board that I'd be happy to present to you today.
Okay, thanks.
I want to begin by thanking Senior Agent Charlotte Ballinger and Supervisor Olya Kolesnikova and Senior Agent Scott Widmar for their professionalism and courtesy in this investigation. This was not an easy investigation, with travel to Armenia, which is not the easiest place to get to from the United States, and of course all the translations necessary of documents. So we truly appreciate their professionalism and their determination to get this investigation completed. BCE Technologies is here before you today seeking licensure as a manufacturer, distributor, and operator of an information service. They want to provide a proprietary race and sports betting system to Nevada race books and sports pools, and provide suggested lines and odds through that system to their customers. Customers will have the ability to accept, reject, or change any of the suggested odds and lines that are provided. If you'll bear with me, I think it is important to understand the history of these applications. For this startup company, it's been an interesting and challenging 4.5-year journey. BCE Technologies, Vahagan Badalian, and Bruce Murati were granted 2-year limited licenses in June of 2018, subject to 6 conditions. 5 of those conditions had to be fulfilled prior to issuance of the licenses. The 5 pre-licensing conditions required that Vahagan Badalian submit documents evidencing that he had the proper visa to conduct business in the United States. In order to get that visa, he had to actually show that he had the right to conduct business in the United States, which case in this case required the license. Once he received the limited license, he was able to obtain that visa and provide that documentation to the board for approval. BCE Technologies was required to have a key employee to oversee the manufacturing and programming of the systems, and to submit an application for finding of suitability as a key employee. The company's technical director and product manager, Armin Vardanyan, who is on your agenda today for licensing, as a key employee, filed his application in compliance with this condition in December of 2018. Armin Vardanyan is here with us today. Vahe Badalian, the company is required to provide evidence of its independence from BetConstruct, was the 3rd condition. So the company provided that evidence in late 2018. It was reviewed by Chair Morgan, who was satisfied and administratively approved it, satisfying that particular condition. 4th condition was that Vahe Badalian, Vahagan's father, whose loans allowed Vahagan to start up the company, was required to file an application for finding of suitability as a lender. Vahe Badalian filed that application again in late 2018 and is on your agenda for approval today. Thank you for allowing Vahe to appear by Zoom. He's with us, I believe, and on the screen today, he and Karine Hakobian, his lawyer there in Yerevan. BCE Technologies, the 5th condition, pre-licensing condition, was that BCE Technologies was required to post and maintain a revolving fund in the amount of $25,000 to fund investigative reviews of the company. That revolving fund has been posted and it remains in place today. I know there's a condition, that condition is repeated on in the board's recommended approval, but as I said, that fund is in place and we intend to leave it in place in compliance with that condition. And finally, while not required prior to issuance of the business, the 6th condition required BCE Technologies to submit its software to the technology division for review. So BCE Technology fulfilled all the 5 conditions required prior to licensing and was granted the license. The licenses were issued in early 2019. BCE Technologies recently submitted its system to the technology division, and has begun a dialogue with the lab. There's been questions and answers going back and forth with the lab engineer assigned to handle that particular their particular submission. And of course, we've got a crash. So the 2-year limited license, during the course of the licensing investigation, and while it fulfilled the pre-licensing conditions, BCE Technologies field trial location changed operators. So they had an agreement with the field trial location. They had a letter allowing them to submit their software for approval, and then they lost that field trial location. The new operator decided not to go forward with the field trial. So the company could not formally submit its system without a field trial location. As it was seeking a new field trial location for its software, of course, we had COVID-19, which shut everything down, as you know. Even after the industry reopened, however, finding a new field trial location was difficult, considering that there were few in-person meetings, there were few conventions, limited attendance at conventions, so there were limited opportunities for the company to be able to meet with potential customers and demonstrate its software to show them why they should make the switch to their software. The 2-year limited license was set to expire in June of 2020. Due to the restrictions from COVID, especially the travel restrictions, the investigations division was not able to complete the renewal investigation by that time. So the board and commission agreed to extend the limited license for 6 months to December of 2020. By then, travel restrictions, especially international travel restrictions, were still in effect and made it difficult to complete the full investigations, especially of Armin Verdanian and Vahe Badalian, who had not been fully investigated in the prior investigation since they only filed their applications in compliance with the condition on the original licensing. So we had an extension of the limited licenses in December of 2021, and again, from December 2020 to December of 2021, and again until this month. So that's why we're here in front of you today. In 2015 and 2016, prior to the Supreme Court striking down PASPA, Soft Construct, which is the gaming company, gaming software company owned by Vahagan's father, Vahe, and his uncle, evaluated the U.S. sports betting market and decided that the Nevada market alone, because it was the only full sports betting market in the United States at that time, was not large enough to generate a sufficient return on the investment to be worth pursuing. Vahagan, who has recently graduated with a business management degree from Exeter University, looked at the market and decided he wanted to start his own small business to serve the Nevada market. As a young man, he could contribute both sweat equity to improve the return, and he was willing to accept a lower return, initial return on investment in order to get the business up and running and to have a business of his own. He convinced his family to support him in that venture and began working to make it a reality. Vahagan has followed his dream for more than 5 years now, doggedly pursuing it and overcoming numerous obstacles. He chose to come to Nevada first to seek licensing and start a new business. From Nevada, he hopes to expand his business throughout the United States. But he hasn't done it alone. Vahagan's father, Vahe, has financed Vahagan's dream and submitted himself to the Nevada licensing process. No small task in order to support the company. I don't think any of his family members expected to take this long to get the business going, but they've stuck with him throughout the process. Vahe has his very own successful companies, gaming, financial, and agricultural businesses in Armenia and throughout Europe. His companies have been licensed in numerous jurisdictions, including the UK, Armenia, Malta, and numerous others. Vahagan also brought in Bruce Marotti, an industry veteran who has been licensed here in Nevada several times. One of Bruce's companies started up and then sold a highly regarded sports betting software product in Nevada. So Bruce understands the Nevada market for sports betting systems. Armin Verdanian worked for Soft Construct before resigning to immigrate to the United States after his wife obtained permanent resident status. She had won the green card lottery and was awarded that status. So he was moving to the United States. And Armin, Vahagan had someone who was already familiar with the core software, had the capability to oversee the process of adapting the software for the U.S. market, and was already planning to relocate to the United States. BCE Technologies found a new field trial, another business partner in the MISPA Club, who's agreed to host the field trial. The MISPA's application for approval to operate a sports book is currently pending. So the board and commission will have another opportunity to review the business model in relationship with the MISPA when that application is heard. The MISPA application is for a kiosk operation. BCE Technologies originally tailored the software for its original field trial location, which was a retail over-the-counter sports book. With the switch to a kiosk operation, they had to further adapt the software to fit that location and meet the requirements in Nevada's regulations, internal controls, and technical standards for a kiosk operation. Once that work was complete, the software was submitted to the technology division. We know that there is one area of concern and would like to address that concern up front. When he was 15 years old, Vahagan attended a school in Cambridge, England. The school was a college preparatory school where he hoped to take his A-level exams, qualifying him to attend a university in the UK. While he had passed the English as a second language exam before he left Armenia, his mastery of English was not as strong as necessary at that time. He was a teenage boy living away from his parents for the first time, pursuing an advanced course of study for his age in his third language. Admittedly, he was having difficulty. Like many 15-year-old boys, he sometimes overslept and was late to school. As a result, a requirement was imposed for Vahagan to have an administrator sign a form each day when he arrived at the school. On at least a couple of occasions, the administrator was not there when he arrived, and not knowing what he should do, he signed the form on behalf of the administrator and added the time that he arrived. The form was simply an accountability measure for the benefit of his parents. Further complicating matters, he had met and started going out with a young woman who was older than he was, and who had also started going out with an even older man. The older man was not happy about Vahagan's involvement and indicated that Vahagan should stay away from the young woman. This disagreement ultimately resulted in an altercation which occurred just before Vahagan was scheduled to return to Armenia for the Christmas holiday. Vahagan ended up with cuts and bruises and a broken ankle. He was in the hospital for several hours the night before his flight home. In light of all the circumstances, he and his family decided that he would not return to the UK for the second semester. He did not complete the course of study. He never took the exam, so he did not technically fail the course. In his mind, it was simply an incomplete. The area of concern results from the fact that Vahagan failed to disclose this school in Cambridge and his brief residence in Cambridge on his application. When completing the application, Vahagan misunderstood the question. He thought that he only needed to disclose schools where he either graduated or failed as part of his education. He was only at the school in Cambridge for 2 to 3 months and did not complete any course of study. He did not take any official exams and did not receive any grades. For that reason, he did not consider it part of his educational data, which is the heading of that section of the application form. When questioned about whether he had attended other schools in a recent interview, his attendance at the Cambridge school did not come immediately to mind. Once he realized that Senior Agent Ballinger and Supervisor Kolesnikova were talking about the school in Cambridge, he realized that he had made a mistake in not disclosing it in the application, when he would have had the time to review the records and make sure the information was accurate. He panicked, frankly. He did not clearly recall the details of his attendance at the Cambridge school, did not want to speculate and say something else, something that was not accurate, because he knew he should have, once it came up, he realized he should have disclosed it in the first place. So he said that he did not remember. But as they discussed it in the interview, it refreshed his recollection somewhat, and he ultimately provided as much information as he could recall at that time, and followed up by reviewing his records and discussing the events with his parents to further refresh his recollection, and then provided, within a matter of days, a more detailed explanation of the events. Vahagan has learned an important lesson from this incident. He now understands that he needs to disclose everything that fits within the wording of the question, regardless of what he thinks the intent of the question may be. We have had a discussion about how he needs to respond to a question when he does not recall all the details clearly. As for the events in Cambridge themselves, again, Vahagan was a 15-year-old boy living thousands of miles from home without parental supervision, taking an advanced course of study in his third language. I can relate to his situation somewhat. At 15, I went thousands of miles away from home without my parents and went to school with older students when I was still having trouble getting myself out of bed in the morning. Even with the advantage of taking classes in my primary language, I still ended up on academic probation. I learned my lesson, fixed my issues, or at least enough for them to get by, graduated, and went on to law school. Do I wish I had handled myself differently that first year? Yes, I do. But it's water under the bridge at this point. Does Vahagan wish he had handled himself differently that first semester in Cambridge? Absolutely. And going forward, he did. He went back to the UK the next year to another school in Oxford, successfully passed the A-level exams, and attended the University of Exeter, where he obtained a degree in business management. I also want to note that he was never charged with a crime. In the fight where he broke his ankle, it appears that the police were going to charge the other man with a crime, but for the fact that Vahagan and his family decided that it was not worth having Vahagan return to the UK to testify against his assailant. Having taken blows to the head and broken his ankle, he was likely given painkillers at the hospital and was possibly in shock. So it's not surprising that some of his recollections of that night are a little fuzzy. After some debate in front of the board recommended a limited license for Vahagan Medallion. While we appreciate their accommodation in not limiting the licenses of the other applicants, we would ask you to consider whether a limitation is really necessary in this case. The licensing process for Vahagan and his company has been going on for 4.5 years. The initial limited license gave them the ability to move forward and obtain the appropriate visa and meet the other conditions imposed, and they met those conditions. The additional limited licenses were granted solely to give the investigations division more time to complete full investigations under the very challenging circumstances that we were all facing at the time. As with all applicants, the company has borne the costs of these investigations. If this commission limits Vahagan's license, they will bear the burden of another licensing investigation in about 18 months. If the company is not hampered in its ability to do business and generate revenue, that would simply be a cost of doing business. But the limitation makes it difficult to sell systems unless there is a prearranged exclusive business relationship. Making a system change is not a small undertaking. Sportsbook operators want to know that the system will be there, will be reliable, and that they won't have to make another change in the short term. While the board's recommended limitation is only on Vahagan's personal license, it nevertheless casts a cloud over the company's ability to achieve its full potential. Nevada prides itself on being a good place to start a business. Vahagan has prepared himself, not only through his education, but also through working in the family businesses. His work in those businesses has taught him about running a business in general and about the gaming business in particular. We're asking you to give Vahagan and his startup company a full chance, without a limitation, to bring a new sports betting system to the Nevada market, to let potential customers in Nevada decide if the product is an improvement over the others currently available, and thereby determine the success of the company. If the system is not approved, it won't be sold in Nevada. If customers don't want to buy it, it won't be installed in Nevada. So there really is very little risk to the commission or the gaming regulatory system in allowing him to go forward in this particular case. This is not a casino operator where there are going to be consumers going in and placing bets and needing to make sure that they are going to be paid at the end of the day. This is a B2B business, and the success or failure is going to be determined by whether the casinos or the sports books actually want to buy this system. So they're asking you to give them a chance to do the work. They know there's going to be more work involved in making this company a success, and they're asking you to give them a chance to do that work. Vahagan, Bruce, and Vahe and Armin all appeared at previous board and commission meetings, but if you would like, they will reintroduce themselves and tell you a little bit about their backgrounds, and we'd be happy to answer any questions either now or after hearing from the individual applicants. Please let us know how you'd like to proceed.
I would prefer to just open it up for questions if that's acceptable to everyone, since we have. Go ahead.
I would like to hear from Mr. Vahagan and
I assume he'll have questions.
Okay.
So we can have an affirmative presentation from him, or we can just go into the questions. If you want an affirmative presentation, we can do it.
only from him. I
Okay,
would like an affirmative presentation.
because I have no doubt there's questions.
Good morning. I've graduated from university. My name is Vahagan Bedulyan. I'm the owner and CEO of BCE Technologies. Just a little bit about my background. I've graduated from University of Exeter. I have a bachelor's degree in business and management. After I've graduated university in 2015, and as Scott told in his presentation, I wanted after self-construct decided not to doing the research about Nevada market and decided not to go enter the Nevada market, I decided to set up my own startup here. And besides that, I've been working in my family-based businesses, both in non-gaming and gaming. Um, I finished working there. I've worked there about 4 years in my family businesses. Besides that, currently we are involved in a project in agriculture in Armenia, which is about 370 acres of pear orchard, which will also expand into a peach orchard in future. And I'm heavily involved in running that business for my father as well. But that's it about me. Thank you.
So I guess, who would like to start?
I'm happy to start.
Would you?
How are you? Thank you for
Good,
coming.
thank you.
It's nice to see you in person. So I have some questions about the application you prepared, and it's my understanding, and if you could maybe elaborate, that you misunderstood the questions on the application. And I would
Mhm,
like to take a few categories. One has to do with residence when you were in Cambridge.
mhm.
The other one has to do with whether, in your mind, the words graduation or taking a test is the same thing as attending. I'm just trying to understand if you misunderstood the questions or if you were not being truthful.
So basically, uh, 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 I filled out the part about my education a long time ago, and when I was asked that, the first thing what I was thinking was maybe I did future. I was thinking in future after like bachelor's, if the question was um, like if I did masters or something. And regarding filling that in, my understanding was because uh, I haven't graduated there. I haven't failed an exam there. That's why I thought that it shouldn't be there. But I understand that it was a mistake, and I'm sorry about it. Yeah.
But it was not an effort on your part to conceal your
No,
educational history.
no, it wasn't, and it was a long time. I wouldn't think that it would. I was 15 at the time, so I wouldn't think it would have issues for me.
Okay. And then the residency component, for some reason, I think you listed all of your other residencies, but that one was not included. Could you
It
just
was
explain what the misunderstanding might have been?
it was 2 3 months. I thought that's why.
So it just didn't count in your mind?
Yeah. I was feeling that because I was adding usually after each time I was updating, and it was 2 3 months. That's why uh, the period.
And I think he lived with essentially billet families, families that supported the school. So he didn't have a residence of his own that he was renting. I mean, he was living with another family there.
So in your mind, when you were reading that application, were you thinking residence that you owned or were you rented? I mean, I just want to understand what your understanding was when you filled it out.
I thought that it was short period of time. That's why.
Okay.
Yeah.
And then there was a comment about police interaction when you read the application and you
Yeah.
filled it out. What was your understanding of that phraseology?
So I thought maybe if I am charged with a crime, I'm arrested, like I made official complaint on someone, something like that. That was my understanding. Even back then, I mean, it's not clear to me because I wasn't at the police station in Cambridge. I was at the hospital, so it wasn't clear in my mind. I don't clearly remember even now if it was. I remember there were people coming in and asking me questions, different people, but I didn't remember if it was any interaction precisely to police. But now, when I think maybe because my leg was broken, it should have been something, but I never recalled 100% if it was or was not.
But when you're thinking interaction, were you thinking that I'm the one that's in trouble versus being the victim? Are you drawing a distinction in your mind?
Yeah, so I thought if I like interaction with police is something, yeah, if I'm arrested or maybe I go and make official complaint to police, even if I'm a victim, maybe those meaning that that's an interaction with the police.
Okay, and then I wanted to talk to you about the form that was supposed to be signed at the school and the administrator wasn't always there. What was your understanding? I heard from council that there was a purpose for parental oversight,
Yeah.
but in your mind, were you forging a signature or were you just trying to maintain a record of your attendance?
Um, uh, uh, I mean, I was 15 at the time, so I didn't. For me, at the time at the school, it wasn't. I didn't take things very. I was 15, so a lot of things were not very important or serious. So I was just. I mean, I don't remember the details, and it wasn't. I mean, I didn't keep it in my memory after the incident because it wasn't very important afterwards because I went to another school and I graduated university. So well, I think it was in attendance, and she wasn't there, and I signed. But that's how I remember what was it.
But at the time when you were doing that, you weren't trying to forge a signature where you were just trying to keep track of your schedule so your parents could understand if you were going to school on time or?
I think they put me there so they see that I'm on time at school.
Okay.
Yeah.
But at no time did you fail to disclose an arrest or something like that?
No,
Okay.
no.
All right. And then how many people are employed with the farm and what's your role?
So I'm mainly involved running it. It's owned by my father, but it's me and my brother are involved in running it. So I mainly run the operation for them. It's seasonal, depending on the work. Now it's a lot less than, let's say, in summers or in springtime, summers and autumn. It would vary from up to 40 people, 20 to 40 people, probably, I would say.
And how do you split your time between gaming, farming, and the credit organization?
I'm not working anymore in credit organization. I attend time to time with my father's meetings in for the bank, but I split my time mainly with agriculture and BC Technologies. Depending on the load, I try to visit the farm 1 or 2 times a week. Other meetings for the farm I do in Yerevan, and at the same time for BC Technologies if anything needs me.
Okay, thank you so much.
Thank you.
Okay, so, you know, I'm particularly interested, not so much in what happened when you were 15, 16 years old, because that's really not the area of concern that I have. I'm more concerned about the interview you had 2 months ago. So I guess the first question I would ask you is, you've had kind of a hybrid explanation for all of this. There's been, I didn't understand the question on the application.
Mhm.
I didn't remember the 3-month school experience. And then I wanted to be 100% clear and not mislead anyone, so I didn't give any additional details until I could refresh my memory. Kind of a three explanations. And I guess my first question would be, do you have any medical or mental health conditions that cause memory deficits? Because you're 29 years old and you were in another country and you were in the hospital and you had a broken ankle. Like, it's not a Tuesday, right?
Mhm.
You have a big event and then you're home right after. And it's not mentioned, according to our investigators, to Exeter or any of your PhD programs, or when they ask you 8 to 12 times, what school did you go to? Are you sure there's no other schools? Are you sure there's no other residences? One moment. Have you ever had contact with police? Ever signed documents on anyone's behalf? So that's why I'm asking. I'm not being facetious. I really want to know.
Mhm.
How do you not remember these things?
Mhm.
Because it kind of looks to everyone
Mhm.
like you didn't tell Exeter, You didn't tell PhD programs, at least that's what they say, that it's not in your application materials listed as a school, right? And that's what our investigation says.
Mhm.
I don't get to speak to these folks right now, but if you feel like that's inaccurate, you should speak up. Meaning, our investigation materials show that your application to the PhD program and college and everything didn't include that 3-month stint at that school.
Mhm.
And so if you think that's inaccurate, I should know. We should know.
Uh,
Well, there was a couple questions there. Let's start with, is that inaccurate?
Inaccurate.
Is that wrong?
You mean the Exeter?
Right.
I had Exeter. I had the university degree, not PhD, bachelor's degree.
Okay. So if they tell us that on multiple PhD applications,
PhD. Okay, application. Okay, sorry, I misunderstood.
right. When you go to school, you have to apply,
Yeah.
agreed? And then you have to fill out
Uh,
forms that list
yeah.
your previous schooling. And what I'm asking you
Okay.
is they tell us, 2 months ago wasn't the first time
Yeah,
that
yeah,
you
I
omitted
understand.
this because
Yeah,
it was 13 years ago, right?
Yeah.
When it was fresher in your mind 3 years later,
Yeah.
you weren't including it on other documents. That's
Yeah.
the point I'm trying to
Yeah.
ask you about.
Yeah. Yeah.
Is
So,
that correct?
my explanation is that I filled out that form. I filled out that the form long time ago, and usually when I was updating the form and when I was being asked, the first thing was in my mind that if I attended like after university, right, like after bachelor's degree, that
What
I
I think you're
didn't.
talking about, sorry to interrupt you, but I just want to make sure we're talking about the same thing. I think you're talking about this application for us.
Yeah.
I'm asking you, our investigators say that the previous school experience was not disclosed in applications to like Exeter, right? And other school programs as
Mhm.
one of your previous school
Okay.
experiences,
Yes.
right?
Yes.
I'm sure you're looking back now like the rest of us saying, boy, it's hard to get into college these days compared to when I went. Because I think it's true, right? And so they're, want to know every little thing about you, and they want a million recommendations, and they want the truth. And so I guess the question is very direct.
Mhm.
Did you, if you recall, disclose this school experience or this school at all in any of those applications?
Okay. So I did not disclose it.
Okay.
Yeah.
I didn't give you a chance to answer, and I said I wasn't being facetious, which might not translate. I'm not being sarcastic, or I'm not trying to put you on the spot, but it's very odd to me that a 29-year-old has so little memory of rather catastrophic events in a very tumultuous time period in his life
Yeah.
that he just doesn't remember.
So if I will explain regarding the fight and breaking the ankle, as I said, interaction with the police, it wasn't clear to me because my only interaction was at the hospital, and I didn't go to police for that. I wasn't taken to police station for that. I just went to home, and there wasn't any complaint for that. So that's why for the interaction of police, it wasn't clear to my memory that there was an interaction, and interaction in my with the police. My understanding was like if I was arrested, charged,
I understand.
or regarding the school. When I was filling out the form, when I was filling, I was thinking if I have graduated or failed. That when I was filling out, that's what was my understanding at the time. And when I was asked, I thought, I mean, I was just answering because that no, because I thought that maybe the question is if I attended before else or after university. Because I always think, okay, it's done, I filled out, so I didn't thought that I should go back or something.
Okay.
That's
So no, you don't have any memory deficits. It's just how you
I don't have
interpreted the
any.
questions
Yeah.
and the application.
Yeah.
I don't mean to speak for you, but I'm just trying to summarize.
Yes.
Okay. I don't have any additional questions about that, so I'm going to defer to who would like to go next.
I can. I have some
Sure.
related questions. Thank you for being here. I had some follow-up questions. They covered some of the questions in my mind, but with respect to the applications before the Gaming Control Board, so that's the personal history disclosures that you've filled out for the Gaming Control Board. When did you first have counsel?
I think in 2000, end of 2015, 16.
Okay, so you had counsel before you submitted your first application.
Yeah.
Did counsel sit with you and explain how to fill out the application?
Usually I just asked what questions I had that I didn't understand, that questions I asked back. So if there were questions that I wouldn't understand what I should write down, I would ask those questions.
Okay, and if you didn't understand those questions, did you ask counsel? Because you're
Yeah.
saying you didn't understand what it was asking for.
No, so what happened, I thought my understanding was that it was either I graduated or failed. Like if I finish studies, or let's say I finish 1 year and I fail. So that was my understanding of the question. And after, when I was asked in October this year, that was my understanding of that question. So up until that moment, I thought that the question, meaning of the question was that I should fill out if I had graduated or failed the university, the school.
Okay, so just to be clear, you had the counsel available to ask questions of if you had any doubt in your mind as to how to interpret something
Yeah.
when you've completed all three of the applications that you've submitted before the board. Is that correct?
Correct.
Okay.
Correct. But I thought that I mean, I didn't have question about the education.
I understand. I just wanted to
Yeah.
make sure that I was clear that it was throughout the whole process. Now, do you understand the difference between attendance, graduating, and failed?
Yes, but I mean, I understand the difference. The thing was that uh, uh, I mean, I thought that I mean, if you are asking when I was asked at the time, as I said, I was thinking, okay, if the question they are asking about something, because in back of my mind, if I fill out the application, I don't really go back and check, because I've checked that, and I just thought that they meant if I did some additional studying afterwards.
Okay. Again, I mean, and counsel, I'm clear on what your position is. I would like to hear what his position is on this. The agents repeatedly asked, and I think they were trying to make sure they gave you a fair chance to respond. That's why they, were
Yeah.
repeating at any, if whether you had attended any other schools at any time. So
Yeah.
I just wanted to be clear on it and I
Yeah.
understand.
Yeah, I understand that it was a mistake from my side.
No problem. With respect to the incident back when you went to school in Cambridge, my issue is not so much with the fact that, you were young, you make mistakes and such, but I don't want to minimize the fact that not only did you sign somebody's name for whatever reason, whether you were trying to forge or just show that you had been there, but you blamed it on a colleague. Do you remember that?
On colleague?
You blamed it on another student. You said another student signed it for you.
No, I don't remember that.
You don't remember that?
No.
Okay. With respect to the software, it was gifted to you by your father's company, correct?
Mhm.
You're the sole member for the Nevada company that you're seeking to operate or manufacture and sell this product to, correct?
Yes.
Do you have exclusive use of that software?
Mm-hmm.
You do?
I was gonna say, could you say yes or no, because the transcriber can't type.
Okay.
Yes.
Just to clarify, exclusive in North America.
Understood. Yeah. And I should have clarified. I believe, yeah, that was in the record. There was a couple incidents where your father's other related company was marketing the product at G2E. If you have exclusive use, why were they marketing the product?
They participate in a lot of expos globally, and G2E has presence in a lot of countries come to G2E
Uh-huh.
from across the world, and especially as well as in Latin America, let's say. So that's the reason they are exhibiting.
Do you recall being asked whether you had any objection to them entering into contracts in North America with respect to the product?
So what will happen if they want to have a deal in North America? They would need to get the permission from me.
Okay. My understanding is that you stated that if the other two companies, Soft Construct or Bet Construct, secured any contracts, you wouldn't interfere because it's a family business. Is that fair?
You mean in North America?
Correct.
No, if they would sign, if they would sign, and if they would sign, they would want a deal or sign or something in North America for gaming because they have other products that doesn't include sports betting. So
Right, and I believe they specifically asked you about that software in sales in the U.S., contracts in the U.S.
yes, but not sports betting.
Okay.
For sports betting, they would need the permit, like we would need to revisit the contract that we have with Soft Construct.
Okay. And just for the record, our records indicate that they specifically asked you about the software that's at issue in this application, about the sports software.
And just for the record, that's not my recollection. I've been in those interviews with him.
Okay.
My recollection was he was clear that, yeah, they wanted to do the sports betting software in North America. My recollection is that if they wanted to do a deal involving the sports betting software in North America, they would have to come back through him. He might be willing to discuss, amending the license agreement, but that they would need to amend the license agreement before they could do that.
And I believe
But
we
they do
have,
have online. They have online gaming software and other types of gaming software.
right, and that's not what the question seemed to relate to. And your recollection is, we do have that in the record as being something that somebody from the other company explained that in the second time they were asked, they would have to go through him. The first time they initially said no, they had full rights to do what they needed to do. So
Bet Construct was asked that? I'm sorry. Or
yeah,
Bahag?
they were asked, I believe the agents asked during the G2E of the people at the booth.
Okay.
And they were asked the first time and they didn't seem to have any understanding of the BCE Technologies companies. The second time they were asked, that's when they said, yes, we're marketing it, but if we have any say of this particular software, we would have to go back through BCE. That's not my understanding. That's what his representation was, that he just wouldn't interfere because it's a family business.
Yeah. And my apologies. I wasn't in whenever they discussed it with Bet Construct. I'm talking about discussions with Bahag and he always, in my recollection of those discussions, couched in terms of for the sports betting software, they would have to come back through him.
Okay, understood. Now,
Bet Construct has many employees. A lot of them might not know about the case with BCE Technologies. They might, their sales team, so their job is to sell, and if they would want to sell, let's say in North America, it would go to other departments, and then the question would come that it needs to go to BCE Technologies.
understood. And I'm not trying to put you on the spot or hold you responsible for
Yeah.
what the employees of a different company said. I was clarifying that
Yeah.
I was asking about the questions that were asked directly of you with respect to the software, and that's what our record indicates. So tell me a little bit about your Nevada office.
It's a small office in Rigas.
I'm sorry?
Yeah, it's a small office we are renting from Rigas. It's a company. We are renting out the office from them in Tivoli Village.
So are you renting more of a mailbox, or do you have
No,
employees
it's an
there?
office. It's
Do you
an
have
office.
employees there?
Employees in US, we have Bruce and Arman, who are the employees, but they are not based in Nevada right now. But because we don't have currently any operation, we will currently we don't have employees because we don't have operation in Nevada. But we plan to hire as soon as we have something going on.
Okay, but right now,
No.
while this office is there
Yeah.
at Tivoli Village, I believe,
Yeah.
who mans it? Is it just closed when they're
No,
not in town?
so there is because we are renting from Rigas, there is a secretary and anything to receive the mail and anything that we need to. And Bruce is when he comes to Vegas, he visits the office.
Okay, so you do have an employee then, a secretary?
No, it's not our rent. So it's like they are, so Rigas, it's like a multinational company who rents out offices and they provide like, they cover the bills. So
Support,
you
yeah.
just pay for the rent and they cover
So you're
the,
just subletting use of space in their office?
yeah. Yeah.
Okay, I
Yeah,
just
but
wanted
it's
to,
a closed office. It's an office. It's not.
no, I understand. I just wanted to be clear because when I looked at your financials, the rent seemed minimal. And
Yeah.
the
It's-
fact that you had no employees, I was just curious as to who manned that office
Yeah.
and what exactly was done in the office other than being available to you and your colleagues if they happen to come
Yeah.
into town. So that's the reason for my questions. With respect to your Armenia office, do you maintain a physical office there? Are you renting that from a related party?
Yes, so the space is owned by a company which is owned by my father and uncle. So I'm just renting out the space from there.
Okay, your financials don't indicate any rent for that location.
No, there is rent. We pay rent monthly for
How
that.
long have you been paying rent at that
Since the
office?
beginning, we have the office from 2019, end of 2019.
Okay. Because I'm looking at financials from 2019 to 2021.
It's BC Tech Armenia's financials or
Yeah,
BC Tech US?
BC Technologies Armenia specifically.
No, there is rent monthly. I see the transactions monthly that we are paying the rent there. Maybe the way the accountant filled out, I think it doesn't go. It's not visible maybe, but it's definitely there. If there are bank transactions, it's visible that there is being rent paid there.
Okay. And that particular company, again, I'm still asking about BC Technologies Armenia. You had some revenue in 2020. What was the source of that revenue?
So the revenue was the government, because of COVID, was subsidizing something like that to software companies.
Okay.
So that's how we received it.
Okay. With respect to the issue of when the agents were gathering data from your electronic devices, you were inadvertently notified that they were gonna do a data collection. Do you recall that? Back in December of, I believe, December 2021, so about a year ago?
Year ago?
Yeah, last year.
No, I wasn't. Last year, I wasn't notified about it. Not last year. They did in May.
Right, they did it in May, but in December, they let it slip that they were going to be doing it. So you had prior knowledge that they were gonna be doing data collection later.
Maybe they did. In December. Okay, yeah. I don't remember if it was in December, but yeah, there was an indication, I think. Yeah.
Okay.
I don't remember the date either, but there was.
Okay. And I'll I'm not trying to trick him. Our records indicate that it was inadvertently disclosed in December of 2021.
Okay.
And knowing that in January of 2022, they obtained new electronic devices and got rid of the old ones.
So in January 2022, I bought the laptop, but I upgrade my laptops when there are new models. I upgrade my laptops. It's just, and all the memory of the old laptop was in the new laptop. So I use iCloud backup or something. So the same memory of old laptop was in the new laptop.
Understood, but we can't verify that now because you got rid of the gaming devices, correct?
Gaming devices.
The computers. I thought it
No,
was
no,
maybe
my
more
iPhone
devices.
was not old. So my laptop was old, but my iPhone was the same. Not the same.
It just said
So
mobile
I
device.
just buy each October when new iPhone is released, I buy new iPhone. So the time when they came, I think it was basically the laptop was a new one. The phone wasn't.
So it was only your laptop that you
Yeah.
changed. Is it indicated that both you and your father purchased new mobile devices in
Not mobile.
January of 2022?
Not mobile laptops.
Okay. Well, I guess they're still kind of mobile. You can take them places.
Yeah.
Have you had an opportunity to look at an email that your father wrote when he was trying to obtain counsel to possibly sue the assailant back in 2009, 10?
I think, yeah, I've read it. I think I don't. I checked a lot of emails about which school and everything. Yes, I think, yeah.
Okay. I was just curious because he seemed to understand that there had been police interaction in that email.
Yeah.
Okay. So maybe he understood it and you didn't. I mean, I realize you were very young, but I just want
I mean, so for me, that indication was the whole story is I broke my leg. The whole story in Cambridge is for me that I broke my leg and I got into the fight. I broke my leg. And because I went to school, I graduated school, I went to university, it was very fast for me. I don't keep like those details a lot. I mean, I never felt that I should keep those things in my memory a lot. So I, for me, it was okay. I broke my leg, and then I went home and flew back. So
understand. And I don't want to beat a dead horse. It just seems
Yeah.
like that would be a pretty traumatic event that one should remember.
no, the
Especially
police,
at your
no,
young
the
age.
breaking the leg, I remember, but because I wasn't at the police station, I didn't I didn't remember specifically that it was any police interaction at the time.
I don't have any further questions. Thank you.
I believe Commissioner Cohen has questions.
Thank you, Chair. At least from where I sit today, we are bound by NRS 463-170. And it's the burden of the applicant on a question of suitability to show that you're a person of good character, honesty, and integrity. And as I sit here, I am troubled by what I have heard and what I have read in our reports. It seems to me, for whatever reason, your story morphs depending on who's asking the questions. I'm troubled by, you've already responded, so I don't want to go over it again. You've already responded that when you filled out the applications, you took it upon yourself that you didn't think it was applicable to go ahead and enter certain information, although you really didn't get that approved by your gaming council at that point. Issues regarding residences, issues regarding, the documents. So as I sit here today, at least I'm faced with it, were you truthful with the staff in the investigation? Were you truthful today? And stories that morph, stories that change with time. I don't hear you saying that you were responsible for these things, that you were mistaken. I don't hear that. What I'm saying is, well, I didn't think it was
I said-
appropriate.
Just because it.
So I just want to get that on the record. Again, there's enough in my belief that you haven't met your burden, and I'm certainly willing to hear any further. I'm just addressing you. I'm not addressing Mr. Marati or anyone else on this application. This is addressed to you because this is where the focus is on your responses. They're no one else's. These are your responses, and they've changed, and they've changed over time. And it's very troublesome when they change over time because I still don't know what the right answer is. I don't know. Anyway, I'll throw it back at Mr. Scher.
May I just respond to that? Because I think you just said a few minutes ago that it was a mistake. It was his mistake. So he's acknowledged that this was his mistake. In my discussions with him, the explanation's always been the same. Perhaps I've chosen to use different words, but that he didn't view this as sort of one of his credentials. That it wasn't sort of a qualification, whether it was for this application, and we weren't, I assume the same is true for the PhD applications. That it wasn't sort of an educational qualification that he had because he hadn't passed, the course, he hadn't graduated, he hadn't failed. So it was essentially incomplete. And again, I may have expressed that in different words. He may express it in different words, but that's been the understanding I've had from him since he and I spoke right after that interview that he had with the agents. So.
Apologies, I missed a couple notes that I had. Are you related to Mr. I'm sorry, Verdanian?
He would be my father's cousin. My father's cousin is his wife.
I'm sorry, could you repeat that?
My father's cousin,
Right, the last part. You said he's a, and I,
his wife. His wife. His wife is my father's cousin.
wife. I'm sorry, I just didn't hear wife.
Yeah.
Okay. And with respect to the applications that are submitted to the technology division, who's responsible for submitting those?
Arman is the technology person and technology director of the company.
Do you review those before they're submitted?
Sometimes, depending on what is it, depends. Because, but it's a technology part, so it's mostly up to him. But we do the calls, we go over them together, depending on the importance or depending on that there's something that I need to add in.
Okay. Our records indicate that, you've submitted the application, I believe, 3 times. The first time it was incomplete, the second time it was presented in the wrong format, and the third time it's finally, I believe, complete and in the right format.
Mhm.
Is that correct?
I think yes, it should be complete. I mean, we will be working with the lab to finish the submit. I mean, we have submitted it, and we will be working if they have any questions. They came back with some questions, and Armand was working on answering them.
Were you aware that it was incomplete initially and
Yeah.
submitted in the wrong?
No, I mean, which one you mean? Which submission? The first
first
time. The time in 2020. You mean?
2020, yeah, April 2020.
I think we submitted it because there are a lot of things we need to know. Maybe we thought it was complete. We submitted it incomplete. Yeah.
And the second time it was submitted in the wrong format.
Yeah.
Does the technology division provide you a format to follow?
Yeah, maybe there was a mistake and then we corrected it.
Okay. I apologize. Those were my only 2 questions. Thank you.
Do you have any additional questions for any of the applicants? Right.
Just one follow-up question. I have an email in my materials from Dr. Marcus Bernhard, and he was the director of studies at the school in Cambridge. And I think there was a reference made by Commissioner Solis Rainey about blaming it on the colleague, but I think, based on my reading of the email, that you made the representation to Dr. Bernhardt that the administrator signed off on the form. Is that correct?
Yes. I mean, if he wrote it, then it should be yes. I don't remember. If he wrote it, then it's yes. Yeah.
But at the time you spoke with Dr. Bernhardt, did you deny that the administrator signed it, or that you signed it for the administrator?
Yeah, I mean, I don't remember like how it went like on word by word, but if the school wrote it that way, then it should be the truth because I don't remember 100%. Then yeah, if they wrote it, then it should be that way, I think.
But as you stand here today, you do admit that you actually signed off because
Yeah.
the administrator wasn't there and you just
Yes.
wanted to memorialize
Yeah.
the date and
Yeah.
time that you were there.
Yeah.
Okay. And did you ever take any tests at Cambridge? Did you ever receive any grades?
So, I mean, school does some tests, but in A levels, it's the official A level exam. So if you do good test or bad test and you get a grade in A level exam, the A level exam is the one that goes on the record and is the one that gets you into university. Others are like just regular school tests. They don't count anything for the university acceptance.
Did you ever take the A level exam?
In school? No. Not
the-
in Cambridge.
Okay, thank you. I have no further questions about you personally.
I'm sorry. With respect to the response that you provided, the written response that you provided to the board,
Yeah.
is that something that you prepared?
We did it together. We did it together with Scott. So we wrote together.
So you and your counsel. I was just curious because it wasn't signed and
Okay. Yeah.
okay. Thank you.
Anything else? Anything else, council?
I would just like to add about that. So I understand that I've made a mistake. So I accept it.
Thank you.
Again, if I might just address especially 463-170. Obviously, Vaughan made a mistake in not disclosing the school in Cambridge, and he acknowledges that. I think he's learned from that. Said in my discussions with him, I think the explanation has been the same, although again, I may have put it in different language than he would put it in. So if that caused it to morph, that's my fault rather than his, and I apologize for that. But this board and this commission has the ability to weigh whether the burden is met under the different facts and circumstances. And I would submit that there have been many much more egregious circumstances than these where applicants have been found suitable and have been licensed. So I think this one particular incident, especially one that when he was very young, one where, again, there was a traumatic injury in terms of the police interaction. It was in a hospital room, having people coming in back and forth, asking him questions. He had a number of different people, is the way he explained it in the interview, asking him questions. He didn't specifically recall that they were police asking him questions, but in thinking back on it, it makes sense to him. Yes, they probably were. And he admitted, yes, that was likely the case. So I think that he has been, is very honest. I know in preparing my remarks today, in reviewing them, if there was something that I said that he thought was going beyond what he could demonstrably prove, that he didn't want me to say it. So in my dealings with him, I found him to be extremely honest, and I do think that he's made a youthful mistake, that he maybe blocked out a portion of this episode other than the breaking of his leg, and that he has learned from this particular incident, is prepared to be very upfront. He understands now that he needs to, as I said in my opening remarks, not just look at what he thinks the intent of the question is or what the relevance of the question is, but look at the actual language of the question and answer it and provide all information that is within the language of that question. So we would ask, as I said, to give him a chance. There's a need for additional software systems in this market. Some of the current software systems are going away. Some of them are obsolete. We're just asking you to give this company a chance to be able to show that its system is one that is valuable and can add value to the industry here. And as I said earlier, the market will decide whether the sports books, the licensed sports books in Nevada, feel that it's an appropriate product for Nevada, for the Nevada market. Only after the technology division has first decided that it actually meets all the standards that Nevada requires. With that, we would again ask for your favorable approval.
Thank you. And we appreciate your answering the questions that we had today. It's now the opportunity for commission discussion and or motion. Who would like to begin?
I can. Mr. Chair, I appreciate your advocacy. I still have serious concerns regarding his business acumen and his integrity, not so much because of what happened 10 years ago, but because of how he handled the current questions. I mean, he's 29 years old now. Those questions just came up in pretty recent history. So that's, and if he misunderstood him, he misunderstood him. But at a minimum, that also affects my view of his business acumen, because he's had very able counsel available. And if there was, especially because of the language barriers, if he had absolutely, any question, he had people available to ask. So that the way the applications have been submitted to the technology division, the financial, I have some independence issue between him and his father's companies because of the financial reliance, and then also his response to the fact that, hey, we're all family, so we're not going to object if they can get the business here. So I have concerns for those reasons, and nothing that has been presented here alleviates those concerns. So that would be my my position, I guess, of where I am right now.
Commissioner Cohen?
Thank you, Chair. I echo Commissioner Solis Rainey's comments. I cannot support this application, as to you, sir. I just feel like you're dancing between raindrops on questions, that were raised today, questions that were raised before the board. And unless any of my fellow commissioners, have anything else, I'm prepared to make a motion.
I have a comment. I'm not troubled by your misunderstanding of the question because of your explanation today. I don't feel like you were intentionally withholding information or lying. I'm sitting here and I'm weighing your credibility. And when you say, like, I didn't graduate from that school, I didn't really live somewhere where I had a residence, I was staying maybe with a family like a host nation family. I'm not troubled by what I perceive as your third language, a legitimate misunderstanding of a question. You don't know you misunderstand it, so you can't get help from your counsel because you're thinking, I've never been arrested. This is not a case for me where you've been arrested and you didn't disclose a DUI or domestic violence. This is not something that's troubling to me. So I appreciate the sensitivity and we have a job to do here, but I think you've met your burden of establishing suitability. You've explained it to me. If you didn't graduate from somewhere and you didn't get arrested, that's how you perceive the question. And you understand now the question had a broader scope and broader implications. You've admitted that you signed a document for the administrator to sign because of attendance. You haven't denied that. So I'm not troubled by true non-disclosure here because it didn't happen. And so I'm prepared to support this application for you personally and for, of course, everyone else. I have no issue with anyone else, but you've established suitability. You've spent so much time and money with this process. I think for the fair market and competitive reasons, it's healthy for you to have the opportunity. You've worked hard. You're not perfect. Nobody here is perfect, but you finally submitted the information to the technology division. It wasn't flawless, but I think you're finally there. So I am not here to hinder that opportunity. And I'm not troubled by your mistaken non-disclosure. It's not, to me, again, like if you did something where you have a criminal history and you just omitted it. I don't see that level here. So I'm not troubled by it, and I simply can't share the sentiments that have been echoed today.
I disagree with Commissioner Brown. It's very clear to me that you willfully omitted information during the interview. I think that when staff asks if you ever signed any documents on anyone else's behalf on several occasions, and you state, quote, he couldn't remember, he would have to go back and look at emails and his father's emails. It's my view that if we're going to be the gold standard and continue to be the gold standard, then, what kind of message do we send to other applicants if we don't hold people to what they are asked and what they answer over and over and over again in an interview, conceding only when confronted with the evidence? So I'm not in support of your application. I respect the most difficult part of this, quite frankly, for me, is not how much money you spent. Or what you've been through, because you're seeking a privileged license, and that's just the way it is. That's you're a grown adult and you're in business. The biggest difficulty for me is that we have two board members that I greatly respect that supported your limited condition license, and Commissioner Brown, and your own attorney's attestation of his beliefs about your character. That makes it difficult for me. But on this record, under Nevada Gaming Commission Regulation 4.0402, I think it's significantly more probable than not that you willfully omitted information relevant and in direct inquiry to the agents that were investigating in this case, and I cannot support your application as a result. Do you have anything to say?
Thank you, Madam Chair. My comments were going to echo yours somewhat in that when it comes to close calls, I generally try to defer to the board. But I felt that the repetition in the discrepancies between the record and your statements was too much, and I'm not prepared to support the application.
Madam Chair, may I?
I feel like this is court. Argument, opposition, reply.
Well,
And so we've all made statements. This is the time for the discussion. And so if there's something in particular, a fact that was stated that you wish to correct, but I'll ask the Attorney General, is it common to have debate with the applicant when they're in the discussion section?
Microphone.
It's not common, Chair.
Okay.
It's at your discretion, whatever you
Okay.
choose to do.
and this is more of a procedural.
Okay.
But before a motion's been made, we can obviously see where this is going. Could this be referred back to the board
Yes,
for the possibility
think so.
to discuss whether we should withdraw this application?
I think one thing is clear from this hearing, which is there were no questions of the gentlemen, other applicants, because of their backgrounds and their histories. So there is no reason that I can see, but if anybody feels any differently or whoever's going to make a motion, I see we have some differences of opinions, so I don't know how this is going to go, but I wouldn't have any objection to that because they're have different interests and different backgrounds and their issues are different as far as I'm concerned. But if you want to comment on that, anyone else?
They don't want to deny, I get that. So.
Well, I think there's going to be a motion at some point by someone, and so Commissioner Cohen, do you have a motion?
A question for the Attorney General. In this particular instance, without a motion, pending, is it appropriate to refer the entire matter back to the board on this record?
That is an option. You can definitely refer it back. I just would caution you of the 120-day rule. Perhaps ask that be waived so we don't run into issues with that.
Well, let's get that on the record. Mr. Chair, on behalf of you and your clients, are you prepared to waive explicitly the requirements of 463-220 sub 6 regarding the 120 days for final action? If you are, then I would make a motion for this to be referred back to staff.
May we take just a moment to confer? Sure. I want to make sure my clients understand.
Sure.
Because essentially this license expires today.
Correct.
So if it's referred back, they will no longer have a license. But I don't know how, if your concerns are with Mr. Vahagan Medallion, how you can go forward with the others.
And
with
just,
that.
I don't have a problem referring it back to staff, but I would refer the entire matter back to staff because he is the sole manager and member of the company.
I understood. That's why I wanted to discuss it with him. Might we take a recess for a few minutes or?
Of course.
Okay, thank you.
We're going to take a restroom comfort break. Wait, I have one. How many questions do you have on the next matter? Because he's trying to catch a flight. It's short. We can take it. Hey, Cohen.
I don't have a lot.
Steve, we're going to try to take Affinity real quick.
I
Please.
don't want him to miss his flight.
Madam Secretary? Are you there?
Yes, yes.
And how's our court reporter doing? Can she do one more matter before the comfort break?
Yes, you can. Thank you, Chair.
Okay, you're wonderful, and I appreciate you. Madam Secretary, could you please read in non-restricted number 4?
Non-restricted number 4, the applications of Affinity Gaming Holdings LLC for an approval of a distribution. The recommendation of the Gaming Control Board is for approval with conditions as noted on the agenda.
Hi.
Good morning. Happy holidays, Chair Tagliati, members of the commission, Madam Secretary. Sonia Vermees from the law firm Brownstein Hyatt Farber Schreck on behalf of the applicant Affinity Gaming Holdings. Also here this morning, Andre Scrivens. He is the CFO, soon to be CEO of the company. Aaron Barnett, Senior Vice President, General Counsel. And also this morning, we have Jim Zenny. He is the founder, CEO, and president of Z Capital Group. He's also the sole director of Affinity Interactive. We appreciate you taking this matter. Mr. Scrivens wants to fly back east for his to see his family for Christmas. And if you've been reading the weather reports, it's bad. So I'm going to be brief as well. Affinity Gaming Holdings is a private investment company registered under Regulation 15C. We filed 2 applications, both with respect to issuing dividends under Regulation 15C 200. We've asked that the second application be withdrawn. With regard to the first application, we would ask that you approve the application as recommended by the board, and we are comfortable with that condition. You have received a confidential presentation deck. You've also received a confidential white paper in support of the application, and that goes through the economic reasons why this makes sense and the policy reasons. And with that, I'm going to go ahead and defer to you commissioners to any questions that you might have.
Thank you. I'm going to open it up to my colleagues for any questions they may have. Start Commissioner Solis Rainey to
Ms.
start.
Vermees, I just had a quick question. I think I understood you, but I want to make sure. You have, you're willing to accept the condition as recommended by the Game Control Board, right?
Yes, we
Rather
are.
than the modified when you had said.
Correct.
Okay, I
Yes.
just wanted to be clear on that.
Thank you.
For that reason, I have no questions. How about you?
I'm in the same boat. Your presentation, very concise. The backup, shows that the money is coming from distributable cash and not from debt, so it's not putting the company in jeopardy, and I'm fully in favor of this.
Thank you.
I echo these sentiments. I have no other questions. Thank you.
So I think we're all relying on your presentation before the board and understanding you have no objections to the conditions. It doesn't appear that there's any additional questions or comments, and at this time it would be ripe for a motion.
Chair Tagliati, I would move for approval of non-restricted item number 4 as read into the record by Madam Secretary and as recommended by the Game Control Board.
Any discussion on this motion? There being none, all in favor, say aye.
Aye.
And there are none opposed. Thank you.
Thank you very much.
Good luck with your travel.
Okay, we're going to take a comfort break. Are we? Madam Secretary? Hard for me to see. Are you there? Okay, let's wait. How about the court reporter?
Yes, I'm here.
Okay, we're just gonna wait a minute. Can you tell me when you see her? I can't see anything. I need. You don't see her, right? No, okay, that's better. Madam Secretary, are you ready to go?
I am.
Okay, we are back on the record. As we took a break from item non-restricted number 3 to allow for counsel to consult with his clients.
Thank you, Madam Chair. Again, for the record, Scott Shearer. I would like to make one request if I could. If there's any way that this commission might consider extending this limited license for 6 months with all the conditions, and allowing them to come back in front of you again 6 months from now and show you that Vahagan has learned from this experience. We've had, this commission, not this particular group, but commission has licensed people in the past who have failed to disclose convictions, and they've still licensed them. In terms of the materiality of this non-disclosure, it simply doesn't rise to the level of what we've seen previously with others who have been in fact found suitable. If the commission's not inclined to do that, then yes, we will waive the 120-day rule and would request a referral back to staff.
Sorry.
Thank you.
Like somebody's undressing on me.
Yeah, it's a little awkward, but. Okay, so I will direct, I guess, first to you because you were referencing the possibility of making a motion. And if you're not comfortable with that and want to have additional discussion or.
Based upon Mr. Scherer's request of this commission to extend for 6 months, I think we should open up for a very limited time to the commission and see what their thoughts are on that.
Oh, go ahead.
Could you turn your mic on?
I'm sorry. Mr. Chair, can you explain specifically what you would want to do in that 6 months? I'm failing to understand exactly what's going to materially change between now and 6 months from now.
Well, I think there are two issues, Commissioner. One is obviously there's been an issue with regard to the technology division submissions. And obviously that 6 months would allow us, there's now a full submission. There's dialogue back and forth. That 6 months would allow us to clear up any issues there. With regard to Mr. Medallion, again, he would have to come back in front of you. There'd be another opportunity for the agents to look at him, look at how he's done business, how he's reacted with, how he's interacted with them in that time period, and has he been honest and truthful with them and open, and again, look at whether this is kind of a one-time indiscretion on his part or whether this is an actual indication of his character. So we're asking for you to give him that opportunity to show that he will be completely transparent with the agents going forward.
With respect to the extension, my main concern is with the business acumen, and I don't see how 6 months is going to really change that. There's not really enough time to have that change. I am concerned with, again, current lack of disclosure, not so much with the lack of disclosure, from his youthful time frame. So for me, it wouldn't change, but I'm open to what my colleagues would like.
Sorry, I think I've already stated the reasons why I wouldn't support, and that doesn't change based upon the request. So I will leave it to anyone who wishes to make a motion as to what they feel, and we can go from there.
It hasn't changed my mind either. I don't think the the flaws in the application could be remedied within 6 months. But I will ask one question for purposes of the record. Assuming that the motion were for denial of Mr. Behagan's license application only. Again, I'm not addressing anybody else because everybody else, I think is in a good stead. What are the consequences of the license expiring today
Well,
for your business?
again, the consequences would they would not have a license in Nevada, so they could not try to sell this system to any other customers in Nevada. They would no longer have a license, so they could not continue to pursue the approval through the technology division. So it would be rejected yet again for another reason. And if they had to come back in the future, they'd have to resubmit to the technology division, which they're willing to do. And again, if the commission's not willing to extend the limited license, then again, we would ask for a referral back to staff and would waive the 120-day rule. But it will again set this business back significantly because they'll essentially have to start over again.
I would simply point out, time-wise, that this information about what the agents asked and the answers only came after he was given a conditional license. Not, unfortunately, you're subject to the changing of this body, and I get that, and that can be sometimes difficult. But had this interview occurred with the let me check my emails before I answer that question, and my dad's emails, respectfully, I'm not sure you would have gotten the restricted license back when you did. So that's just kind of my 2 cents. But in any event, usually I don't make motions. So I'm happy to entertain any that anybody has. Are you making a motion?
No, I thought he was going to.
You want me to?
Well, I'm just asking if anybody has a motion.
I have a motion. I move to deny the application of Behagan Vidalian as read into the record by Madam Secretary on the grounds that the applicant failed to meet the standards outlined in subsections 1 and 2 of NRS 463-170 by failing to demonstrate good character, honesty, and integrity as discussed on the record, including but not limited to questions regarding the business acumen as displayed by the applicant. So we'll address that motion first, then we'll go to the second part, your waiver, and then referring it back to staff.
I think if that motion's approved to be over and we wouldn't be able to address the second part.
Yeah, I
So-
think I have a competing motion just for the referral back without the first part. I'm prepared to support that, but not the denial.
Okay, so let's look at our council.
So you have a motion on the floor, so either you need to withdraw that motion or take a vote.
But you agree with the suggestion that the motion as made doesn't renders any referral back moot, correct? See, because I'm seeing furrowed brows from our AGs, and so perhaps
No, it does not. I think you can refer the other items back and restructure or do what needs to be done in order to remove Mr. Vidalian from his position, replace him,
that's what I thought we
or
were.
withdraw that application.
That's what I thought we were talking about. If we refer it back, the company has an opportunity to regroup. And if the 120 days is waived and someone else becomes the sole proprietor or however they're going to structure it, that could be considered. Is that correct? Even with this motion, because that would be the subsequent motion.
That's correct, Chair.
And you disagree because?
Well, I disagree that if he's denied, then he'll have a denial, and that will mean that he can't contract with a licensee without further approval under, I think it's 463-165. So
If- If I
I
may
agree, and I wasn't-
interject,
We're going to deny him. I thought.
Chief Hoffman here from up north.
Yes, Chief.
Just want to put the reminder out there that there's also the option to, fairly recent option, but an option to reject an application. and take no further action?
That's only if the board were to deny the application and it comes before the
Oh.
commission has the opportunity to reject. So it's not available
see.
here.
Misunderstood that.
Yeah.
That's what.
I'm prepared to support a full referral back to staff because I agree with Mr. Scheer. I mean, I think it would cause problems with, him ever having any association with this entity. So I was prepared to refer it back to staff and allow him to withdraw if he wishes, or have the company restructure if they wish. Not ideal, but that's kind of where I was at.
I'll withdraw the motion for denial, and make a different motion, based upon your express waiver of the 120-day rule pursuant to 463.220 sub 6. I would move that the remaining applications be referred back to the Nevada Gaming Control Board in order for BCE Technologies to reorganize and or remove Behagan Vidalian from the company structure, or withdraw the application from the board.
And just, you did waive it. I missed that
Yes.
part. Okay.
Absolutely.
I'm making sure I understand that. Okay, is there any discussion on this subsequent motion?
With the subsequent motion of referral back, there were specific items identified, and I don't want to limit you to those specific items. So I think you said restructure, removal, or withdrawal, and I don't know what else they could do, but I don't want to limit them based on the scope in terms of the ambit of what you've just proposed.
For purposes of the motion, we have to provide certain reasons for the referral back. Those are a number of reasons, but I'm not trying to foreclose you from coming up with other methods.
Okay, so,
including but not limited to.
Yes, including but not limited to.
okay, so the record will reflect the motion was amended to include language, including but not limited to those, that checklist there. Any other discussion on the motion? There being none, all in favor, say aye.
Aye.
And opposed? There are
Thank
none.
you. Merry Christmas.
Thank you.
We'll miss you on the commission, Commissioner Kekeffer. Good luck in your new position. Thank you.
Madam Secretary, could you please read in non-restricted number 5?
Non-restricted number 5 is the application of IBOCM Boatco to pledge membership interest as noted on the agenda. It is also the application of Interblock Luxury Gaming Products Limited, doing business as Interblock DOO to pledge membership interest as noted on the agenda, and for a waiver of Nevada Gaming Commission Regulation 15C.010(1)A as noted on the agenda. The recommendation of the Gaming Control Board is for approval with conditions as noted on the agenda. I believe we have a recusal on this item.
Thank you, Madam Chair. For the record, I need to disclose that I'm an employee of the law firm McDonald Carano, which has worked on this application in partnership with Ms. Okerberg, and for that reason, based on this pre-existing financial relationship, I need to recuse myself.
Thank you.
Good morning, Chair Tagliati, Commissioners, Madam Secretary. For the record, I'm Erica Okerberg, outside Nevada Gaming Counsel to Oak Tree and to IBOCM Boatco. Here with me today is Heather Rollo from Interblock, as well as David Quick from Oak Tree. If I could, I understand that the Commission has had an opportunity either to watch the board meeting or read the transcript, so I will give just an abbreviated review of the applications before you. First, we have some equity pledges in connection with the term loan and revolving credit facility that was entered into to finance the acquisition of Interblock. And Heather will provide an update on the company and finances in just a moment. And the second set of applications relates to a waiver request under NGC Regulation 15C.010 sub 1. This provision requires that 100% of the economic securities of the private investment company be held by private equity funds. And in this case, we're requesting a waiver to enable the creation of an employee equity incentive plan. And I believe you have a white paper in your materials that describes the policy rationale and the details around that plan, including some important controls to help maintain regulatory structure. Again, I will just note for the sake of the record that those shares pursuant to the plan would be economic only and non-voting. If there's any questions on the applications, I'm happy to answer those. Otherwise, I can turn it over to Ms. Rollo.
I think we can turn it over.
Wonderful. Thank you.
Okay.
Thank you, Erica. Good morning, Chair Tagliati, Commissioners, Madam Secretary. For the record, I'm Heather Rollo, the Chief Financial Officer of Interblock Gaming, And I'll give you a brief financial overview of the company following the acquisition by Oaktree in June of this year. As Erica referred to, we did refinance our debt in connection with that refinancing and expanded the debt to provide some additional growth capital to the company. So following the acquisition and going into next year, we have a strong balance sheet and the ability to continue to invest in our growth. Interblock has seen significant growth here in North America. That growth really started following the reopenings after COVID. Our product, the electronic table games product, was a product that the casino operators could use to save labor as well as comply with social distancing requirements at the time. But following that, the company has continued to see adoption of this product. We really believe it's in the early stages of adoption in North America, and so we expect continued growth in 2023 and beyond. Also, in the second half of this year, we did see a number of our international markets open up. So Europe appears to be opened up fully, and we expect some strong demand in that market, as well as Latin America. And then in 2023, we expect the Asia Pacific markets to be more open and a meaningful contributor to our results. To facilitate this growth, the company has made substantial investments in people. So we've increased our workforce here in Nevada primarily, but the US by almost 25% in the last 2 years, as well as made some additional investments in R&D. So at this time, I'd be happy to answer any questions the commission has.
Just to be sure, it's my understanding that none of the employees would have any voting or control rights over Interblock, and that we have the full discretion to require any employee who acquires the shares per the plan to apply and to be found suitable. Is that correct?
That's correct. You
Okay.
retain that authority under 15C.070.
Okay,
Thank you.
thank you.
Excuse me. Commissioner Solis Rainey,
I didn't have any questions. Thank you.
Commissioner Cohen.
I have no questions. It's proper under Regulation 15 C.
And based upon, how the commission, the board and the commission have handled this issue in the past, it seems, I have no additional questions. I appreciate the materials, the presentation that we're familiar with before the board, and I'm prepared to call for a motion.
Thank you.
Chair Tagliati, I'm prepared to make I actually moved to approve non-restricted item number 5 as read into the record by Madam Secretary and is recommended by the Gaming Control Board.
Okay, any discussion on the motion?
The only discussion I have is the confirmation that the conditions that were set forth before the board are going to be adhered to.
Yes, and it is in proper form.
Okay, thank you.
All right, all in favor of the motion, say aye.
Aye.
Aye. And there are none opposed. The record should reflect that Commissioner Keycapper did not participate in the discussion or vote on this matter. Thank you very much.
Thank
Appreciate
you.
your
Happy
feedback.
holidays.
Thank you. Madam Secretary, can you please read in non-restricted number 8?
Non-restricted number 8 is the application of Ana Carrillo Munoz for licensure as a key employee at LGS Casino LLC, doing business as Lucky's Gaming and Spirits Casino. The recommendation of the Nevada Gaming Control Board is for approval. I believe we have a recusal on this item.
Thank you. I do have a recusal. My husband, David Brown, is representing the applicant, and I must therefore recuse myself from voting on this matter, and I will step out. Thank you.
Thank you. Good afternoon by 2 minutes.
Okay, good afternoon, everybody. David Brown on behalf of the applicant, Ana Carrillo Munoz, as well as the owner of Lucky's Gaming and Spirits, Alan Hamika. We'll be very brief. This was approved on a temporary 2 years ago. I think over the last 2 years, Ms. Carrillo Munoz has learned a lot about filing tax returns. She did all the necessary admitted tax returns. The total amount that was owed was $2,131, and that's been paid in full. Happy to answer any questions if you have them.
I have just a couple of quick questions. With respect to the tax returns, it looked like, I apologize, let me find my note. The board was unable to confirm payment of the taxes that were owed for 2014 and 2015. But since those were just amended in November of 2019, why was that information not available?
There was an issue with the amended tax returns not being filed. So they were recently filed, and we did submit proof of payment for both of those years.
You did? Okay.
Yes, we
Yeah, I
did.
must,
To
okay.
Mr. Muller. But it was late. It took longer than expected, but we were able to show proof of
Okay.
check. I don't think it had been cashed yet, so we can't show it being actually taken out of the account.
Understood. Thank you so much. And then I had a quick question for either of the Ms. Carrillo or the gentleman. I apologize. My notes got messed up. With respect to the computation of statistical win, are you responsible for doing that in the submissions to the board about statistical win?
No, we actually have our, I'm sorry, Alan Hamika, Just Casino LLC, managing member. We actually have the CPA firm, Ovison Howard, who handles all the gaming fees for us.
Okay.
So
All right. I was concerned just with the recurring violations. It's only one, I believe, but for some reason they can't seem to get that computation right. And it's something that once it's in place, it should, be pretty simple to follow it from month to month. So I was just curious on who was responsible for that.
yeah, we actually got that handled with Golden Entertainment. We were having some issues with their plan tracker management system, but we've spoken several times with their controller, and we've got it taken care of. So moving forward, I believe as of I want to say October of this year, the reports are coming in correctly.
Okay. And Ms. Carrillo, I understand I watched the board presentation, so you do understand that it's your responsibility to review your tax returns.
Ana Carrillo, for the record. Yes, I do understand that it's my full responsibility.
Yeah, although, I'm comfortable because we received the confirmation from Liberty Tax Service that the error was something that was, caused by them, but you did sign them. So I would just caution you to make sure you review those in the future.
Yeah, no, it was their mistake, but I take fault for it too because I signed it without reviewing them.
Okay, thank you.
I was just going to say the same thing about the tax service. I appreciate that information was given to us, and quite frankly, you almost need to be an IRS agent these days to do the taxes, but it is your responsibility. And so I don't have any additional questions beyond, I was going to ask those same questions.
Mr. Miko, I'm sorry, I just drew a blank and I couldn't find my notes with the name. So
Sure, no worries.
thank you for being here.
The issues have been clarified and cleared up. So I'm prepared to support this application.
Okay. So at this time, it appears that this matter is ripe for a motion, this item. Yes.
Thank you, Madam Chair. I would make a motion that we approve non-restricted item number 8 as read into the record by Madam Secretary and recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor, say aye. Aye. And it appears there are none opposed. The record should reflect Commissioner Brown did not participate in the discussion or vote on this matter. Thank you.
Thank you very much.
Thank
Have a
you.
great holiday.
Madam Secretary, I need Commissioner Brown, sorry. Madam Secretary, can you please read in non-restricted number 9?
Non-restricted number 9 is the application of William Valdez for licensure as a key executive at TA Operating Nevada LLC. The recommendation of the Gaming Control Board is for approval. I believe we have a disclosure and a recusal on this item.
Thank you, Madam Chair. For the record, I need to disclose that I'm an employee of the law firm McDonald Carano. The firm is representing the applicant in this matter, and based on this pre-existing financial relationship, I need to recuse myself.
I do have a disclosure. TA Operating LLC is an affiliate of Travel Centers of America, a client of Louis Roca, the firm where I am a partner, in an unrelated rezoning matter in which I'm not personally involved. I have no pecuniary interest in the outcome of this agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. Thank you.
Good afternoon.
Good afternoon, Chair Tagliati, members of the Commission, Madam Secretary. For the record, Greg Giordano, the law firm McDonald Carano, appearing here on behalf with the applicant and TA Operating Nevada LLC, applicant being Bill Valdez. With me at the podium in Carson City is my colleague Kelsey Benu and the applicant Bill Valdez. And with that, Chair, I'll turn the rest of the proceedings over to my colleague Kelsey Benu to go forward with them, and with their permission, we'll go with with Ms. Benu in Carson City.
Thank you.
Thank you, Greg. Good afternoon, Chairwoman Togliatti, Member Solis Rainey, Member Cohen, Member Brown, Member Kekeffer, and Madam Secretary. Thank you for letting us appear in Carson City today. For the record, I'm Kelsey Benu with McDonald Crono. As my colleague, Mr. Giordano, mentioned, we're here on behalf of TA Operating Nevada LLC. With me this afternoon is the applicant, Mr. Bill Valdez. Mr. Valdez is the Vice President of Gaming of TA Operating. The application before you is for the licensure of Mr. Valdez as a key executive, Vice President of Gaming of TA Operating. I believe that you've likely watched the Gaming Control Board meeting or reviewed the transcript or have it in front of you, so we'll keep this brief. As Mr. Valdez gave an affirmative presentation at the board meeting, at this time we'd like to ask if the chair or commission members have a preference for Mr. Valdez to introduce himself briefly, or if you'd like us just to open it up to questions. Thank you.
I will ask my colleagues if anyone would like an affirmative presentation. We're going to open it up to questions.
Perfect.
So, starting with Commissioner Solis Rainey, do you have any questions?
I don't have any questions. Thank you.
Commissioner Cohen?
I have no questions.
Commissioner Brown?
Hi, Mr. Valdez. How are you this afternoon?
I'm good. Thank you. How are you?
I'm well. Thank you for asking. I just wanted to show my appreciation and thank you for your full disclosure, notwithstanding the fact that the records were sealed. I do appreciate that very much. I think it's very important.
Thank you. You're welcome.
And I have no areas of concern. I'm prepared to support the application.
Thank you.
And I would echo the comments of Commissioner Brown. And I don't have any additional questions. So at this time, it would appear this matter is ripe for a motion.
Thank you, Chair. I move for approval of non-restricted item number 9 as recommended by the Gaming Control Board and as read into the record by Madam Secretary.
Any discussion on the motion? There being none, all in favor, please say aye.
Aye.
And there are none opposed. The record should reflect that Commissioner Kekeffer did not participate in the discussion or vote on this matter. Thank you.
Thank you very much, and happy holidays.
Thank you.
Thank you.
Thank you. We would just like to recognize Agent David Hearn for his work on this file. So thank you so much. Happy holidays.
Thank you all.
Thank you.
Happy holidays.
Thank you. Okay, at this time, we're going to move to the restricted items held out for discussion. Madam Secretary, if you could read in restricted number 1.
Restricted number 1 is the application of 7689 Tavern LLC doing business as the Parlor for a transfer of interest is noted on the agenda. The recommendation of the Gaming Control Board is for approval with conditions as noted on the agenda. I believe we have a recusal on this item.
I believe for the last time, Madam Chair, I need to disclose that I'm an employee of the law firm of McDonald Crono, and this application being represented by Mr. Hicks of the same firm. As such, I need to recuse myself from participating on this matter. Thank you.
Good afternoon,
Good
Madam
afternoon.
Chair, and if I may, to Commissioner Kekeffer, I'm sorry to see you leave the commission, but you never voted for any of my applicants. But you'll do a good job, and I think it's quite an honor to have been invited to be the governor's chief of staff, and I think you will greatly help him out as he makes this transition during these difficult times. Madam Chair, members of the commission, I'm Bud Hicks with McDonald Crono Law Firm. The application today seeks the approval of a transfer of interest among presently licensed persons in 7689 Tavern, a bar tavern operation located in Reno known as the Parlor. If I may take just a minute, I represent the company, and I have with me, or present with us today, the principals of the company, and I'll ask them to stand as I introduce them. Mr. Jason Talati. Jason, if you'll stand, please. He's my son-in-law, and you'll recall we were here a month ago in front of you. Mr. Steve Chemierewski, who is a partner, a member in the company, and in Carson City is Mr. Justin Moscove, and we appreciate your allowing him to attend by video conference. He had shoulder surgery 10 days ago, I believe, and it's difficult for him to fly with his cast. Now, as noted in the agenda for today's meeting, approval is requested for the transfer by Mr. Chemierewski of 9% of the interest that he owns in the Parlor to each of Jason Plotty and to Justin Mosk. So it's a transfer among presently licensed persons. As I stated, you may recall Mr. Talati and Mr. Moscove appeared before you a month ago in connection with the restructuring of the Flowing Tide pubs. That's a different set of operations from the Parlor. The Parlor is a standalone that is owned and operated by the three principals who I've just introduced. The transfers sought to be approved arise out of a dispute that arose between the three members of the company that has been fully disclosed to the board staff and was discussed at this month's meeting of the Nevada Gaming Control Board. The principals are here to answer any questions you may have about that dispute that arose between themselves and the settlement they have negotiated between themselves. Now, as you know, the board recommended approval of the transfer of interest application and has requested Mr. Chemierewski to file a supplemental application to again be investigated and hopefully to be found suitable in his additional role as the on-site general manager of the location. Mr. Chemierewski has agreed to prepare and file this application. Now, Madam Chair, if you would like, I can go through the summary of the dispute that we discussed at the board, or we can just simply make the principals available for your questions.
Please.
Well, the dispute between the members of the company relates to the misuse of some of the funds used in the operation of this business by Mr. Chemierewski. Mr. Chemierewski has served as the on-site general manager of the Parlor since its opening in the fall of 2020 to the present. Prior to his participation as a member in the company and as the on-site general manager of the Parlor, he worked for approximately 10 years as a bartender and general manager of one of the Flowing Tide pubs located in Reno. Throughout these years, he earned the respect of Mr. Talati and Mr. Moscove, who believed him to be a very hardworking and very capable employee. In 2019, Mr. Chemierewski advised Mr. Talati and Mr. Moscove of his interest to become an owner of a bar, and he brought to their attention an existing bar opportunity that was struggling at the time in Reno. It was a good location and it had a great layout of the bar. This led to discussions between Mr. Talati, Mr. Moscove, and Mr. Chemierewski, and negotiations with the then present operator and landlord of the location. A lease was negotiated and signed in November 2019, and the parties thereafter formed the company for the purpose of redeveloping the location and operating it as the Parlor. The parties further agreed that Mr. Chemierewski would work at the location once opened as its on-site general manager, and that Mr. Talati and Mr. Moscove would provide advice and backup support on an as-needed basis. Unknown to them at the time, and indeed to all of us, the COVID pandemic struck in the United States shortly after the end of 2019. Unable to determine how long the pandemic and its related limitations would continue, the parties stuck to their original business plan to redevelop the premises and get the location open for business. This involved significant expenditures of funds and efforts to get the business ready for open and ultimately to open it. In addition to the time and efforts needed to redevelop the Parlor and to get it open for business, Mr. Talati and Mr. Moscove were also distracted by the problems that the pandemic posed to their other bar operations, including all of the Flowing Tides and Mr. Talati's other bar, which is located in Verdi, Nevada. The Parlor opened for business late in the summer of 2020 amid various limitations and impacts of the pandemic. Fortunately, due to Mr. Chimiruski's day-to-day management of the location and the oversight provided by Mr. Talati and Mr. Moscow under these very difficult conditions, the Parlor gained a good following and was able to survive the difficulties of 2020 and 2021. However, the stress and strain of operations took a toll on Mr. Chimiruski. In the late fall of 2021, Mr. Talati and Mr. Moscow, in the course of their oversight of the business, noticed that the revenues reported at the Parlor didn't seem to match up with the trends that they saw in their other bar tavern locations. And so they undertook a quiet review of trying to figure out what was going on. That led to a meeting between the principals, including Mr. Chimiruski, in the first week of this year, 2022. And when he was asked about the problems identified by Mr. Talati and Mr. Moscow, Mr. Chimiruski admitted to and took responsibility for misusing substantial sums of the company's cash derived from operations to fund his personal gambling habit. Further discussions revealed that despite his efforts to replenish the sums he misused for these purposes, he had fallen deeper and deeper into the hole he had dug for himself. Quite practically speaking, it's something that those of us in the business have seen on a repeated basis from people that have gambling problems. They all think they can repay it from their winnings, and they just tend to dig a deeper and deeper hole. And that's what happened. Following further discussions between themselves and the implementation of additional controls and oversight procedures, Mr. Talati and Mr. Moscow have agreed to allow Mr. Chimiruski to continue his employment as the on-site general manager of the Parlor, subject to the terms and conditions of the settlement agreement they negotiated between themselves. Again, it was during this very difficult time when it was hard to get help, and particularly experienced managerial help. And so this seemed to work, and they had the confidence in Mr. Chimiruski to give him this chance. So far, Mr. Chimiruski has complied with the terms of the settlement agreement. He has sought professional help regarding his problem with gambling and seems to be getting it under control. The property has continued to do well under his day-to-day management and has indeed generated enough profits from the business to allow him to repay the full amounts of the sums that the parties agreed among themselves were misused during 2021. With all of that said, Mr. Chimiruski is present today to answer any questions you may have of him. He submitted two letters to the board in connection with what he has been doing to help himself. And so far, the property has been doing well. Mr. Talati and Mr. Moscow can confirm that their controls and daily reviews of the cash in the business have shown that Mr. Chimiruski has not repeated any of the sins of the past. And so we have a difficult situation here. And as a result of that, and if I can just sort of give my view of it, the control board, they were concerned with Mr. Chimiruski, and that's a rightful concern. And so we suggested that, they are all three licensed now. They've all been through the process, including Mr. Chimiruski. But we suggested at the board hearing that, obviously the board could file a complaint against him to find him unsuitable, or alternatively, find some other avenue to take another look at Mr. Chimiruski. And so we offered up that the board consider requiring him to file an additional application for a finding of suitability as a key employee being the on-site general manager of the bar. He is presently licensed as one of the co-owners of the bar. And so I don't mean to speak for the board, but obviously I think the board came to the conclusion that this was a way to take another look at Mr. Chimiruski to see how he's progressing with his handling of this problem and the treatments that he's receiving, and then to have another look at him. So that's where we are. on this, and we hope that the commission will follow the board's recommendation. But we are here today with all three principals and ready to answer any questions that you may have.
Would you like to start, or do you have any questions?
I have questions, but she can start. You can go. So in the avoidance of doubt, sir, it's my understanding that the conditional approval of the transfer is conditioned upon the subsequent suitability application of Mr. Chemerinsky. Is that correct?
No, I don't believe so, Ms. Brown. I'm not sure that the agenda properly reflects the action, at least not according to not along my recall of what happened. We had a discussion at the board about this. Number one, first, Mr. Talati and Mr. Moscow, they would like to get this part of the settlement between themselves all concluded. We'd like to do that by year's end. So it was my understanding that assuming we get the approval today, that they can go ahead and close it, and that Mr. Chemerinsky has made a commitment to the board, and he's willing to make a commitment to you today that within 60 days he will file a new application and go through the process again, and let the board take a look at them at that time. But it's not, the transfer is not specifically conditioned on either his filing the application or him being found suitable.
So my understanding then is it would not void the transfer, but it's a condition nonetheless. Does that make sense?
Well, I suppose it's
That's how my reading of the transcripts. I was careful about the wording because that was my understanding as the board recommended it to us, that it was a condition of the approval of the transfer, which would be effective immediately to the extent we approved it today.
I think it's a condition that he has agreed that he will prepare and file the applications. And obviously, if he doesn't, then presumably the board would file an application or a complaint against his present license. So he has skin in the game on this.
So there are ramifications if he doesn't, but it doesn't void the transferability that's approved today.
It does not.
Okay, and that's my understanding. And then could he stand before us and make a short presentation about what
Sure.
transpired? Because is that okay, Chair? Sure. Thank you.
Sure.
Good afternoon. I suppose the best way to go about it is to read the letter I wrote to the board, but also to Jason Talati and Justin Moscow. I am a gambling addict. I have always been a gambler. It started with playing poker with my grandmother as a child. Even during her dementia, she was still excellent at cards. And when I came of age, I used to take her to the Carson Nugget as an activity we did together. For more than a decade, I gambled, always within my means. But in 2020, with the help of my former bosses and good friends, Mr. Moscove and Mr. Talati, I fulfilled my dream of opening my own restaurant and bar. The Parlor's opening was delayed due to the COVID pandemic, and I could not bartend and was essentially unemployed, and the money quickly dried up. The stress proved to be unbearable and counterproductive to my problem. I began gambling beyond my means to help mitigate the stress of financial insecurity. After the closures and restrictions began to subside, I began to make money again, but by this point I was upside down with gambling losses. I began to use the funds from the restaurant to subsidize my play, always with the intention of paying it back. I kept a log of what I owed and always hoped to hit a few jackpots to get back to even, but the hole seemed to get deeper and deeper. After it got to the point of no return, I began to see a therapist to help me curb the addiction, but it was too late, and I came clean to Mr. Talati and Mr. Moscove. At first, they were understandably furious and disappointed. I screwed up beyond even what I had imagined. I love my partners like family, and I betrayed them in ways that I can never recover from. I agreed to transfer a portion of interest in the restaurant to them and pay all accumulated debts. Worse than the financial hole I put my wife and myself in, I feel the shame about hurting my friends. The Talati and Moscow families have begun to work out our situation, and I hope to one day regain their full trust and to prove to them that I can be a reliable partner and a good friend. I want to thank them for supporting me and helping me guide me out of such a grievous mistake. I will continue my mental health treatment, take my medications, and find healthy legal ways to deal with my stress. I have since returned to the gym, gone back to fly fishing, and focus on making the restaurant as successful as possible. I will comply to the full extent of whatever the commission recommends and work hard to regain the trust of the Gaming Control Commission, my wife, and my partners and their families. Thank you for your consideration.
Thank you, sir. And so the total amount that was misappropriated, was that $225,000?
Madam Commissioner, we would prefer not to discuss financial affairs in the meeting, but it was a substantial.
Okay. I didn't see that that was marked confidential. I'm sorry.
Oh, we had requested that it be marked that way. But
Well, just for the record,
it's in the record.
we're entitled to ask anything we want to ask
Yes.
pursuant to statute. So I mean,
Yes,
there's that.
That's a correct amount.
Okay. And then there's been a full repayment of a certain amount. If you don't want to talk about it, that's fine. But I just want to make sure that's been fully repaid to date.
Yes, ma'am.
Okay. And so is the transfer of the 9% to each of your partners for a total of 18% part of that repayment, or is that as an apology? I'm still not clear about that.
Yeah. No, it's actually different because Mr. Moscow and Mr. Talati said that if they got the money back that was owed to them, basically, the money that was taken, it was basically, it would have been distributed as profits that year. And so at the time, each of Mr. Moscow and Mr. Talati owned 26% of the company, and Mr. Chemerinsky owned 48%. So, the overall number, that meant that 52% of that, which was owned by Talati and Moscow, had to be repaid. It was repaid because out of profits of the company, it's sort of a complicated settlement agreement, but he gave the company and them a lien on his share of the profits up to the amount that he owed. And we didn't know if there would be profits sufficient to pay by the time we stood in front of the board and today in front of you. But fortunately, the company has been very successful. So they have paid off all of the sums. So there's no harm, no foul in terms of dollars. Now, on the transfer of interest, that's sort of a different part of the transaction. It requires different consideration that will be paid by Mr. Moscow and Mr. Talati to Mr. Chemerinsky once if the transfers are approved. And the way they got to the number that of the amount they're each going to pay for that additional 9%, they negotiated between themselves and determined based on some industry standards on profitability and all of that, what the value of that 9 plus 9, 18% interest was.
Okay, thank you for that clarification.
So they will have to they will write checks to Mr. Chemerinsky when the transfer occurs, assuming it is approved.
Okay, thank you for clarifying that. And then my concern is in connection with the cash bag. Are there any checks and balances in place to ensure that those funds will not be misappropriated by Mr. Chemerinsky in the future?
I'll ask if I may have Mr. Talati come up because he's directly involved in that.
Chair Tagliati, Commissioners, good afternoon. Jason Talati. Okay, yes, good question. We have put additional measures, significant measures of daily audits. We are overseeing every weekly drop from our route operator, either Justin or myself. And Steve or a manager sends us a picture of our daily audit spreadsheet that we've created that we personally see every morning. And so we can spot anything that looks out of whack at any point. So and there's some additional supervision that's been put into place on more of a not necessarily daily but at least weekly basis in there.
Thank you. And does Mr. Chemerinsky still have check writing authorization? Because it was my understanding that the slot route operator would drop off the cash bag. He would take those funds and then write a check to cover it something to that effect?
Yes, and
Okay.
he still does have those, that responsibility. So, but we know every check number and, everything's,
More oversight this time
yes,
around.
absolutely.
Okay. And then, Mr. Chemerinsky, could you tell me the increments that you were taking? Is my understanding this was only in 2021, nothing in 2022. Is that accurate?
I believe so, yes.
Okay. And what were the approximate increments?
It escalated like any gambler would. And then there was times where I would hit and pay back chunks. So a definitive amount is kind of hard to come by, but I would say in the 1 to 3,000 range,
And would that be every week?
periodically.
Okay.
Not
Okay. Thank you. I have no further questions.
I don't have questions with respect to the transfer of interest. The other ones, I guess we can hold. I was mostly concerned with your well-being. You're continuing to seek treatment? Does being around the gaming operations create any problems for you?
Um, to be honest, sometimes it can. It's hard to see people win large jackpots. The restaurant does well. We have some substantial high-end gamblers, but I go to therapy every Monday at 11:30 with somebody who specializes in this. It's been very beneficial. And my wife and I started seeing a couples counselor so that she has open oversight over my mental health, and we work on honesty and everything like that. So.
And none of the gaming happened at your establishment, correct?
Unfortunately, some of it did, but I have been counseled that that was not allowed, and I was not aware of that before.
Thank you. I don't have any further questions. Thank you.
Make it clear. Sorry. Can you hear me all right? Okay. Just to make it clear, this is just a transfer of interest. That's all that's before us today, and it's to reduce his interest, not increase. And any other issues related to suitability and everything else will be subject to that additional subsequent investigation that the board intends to undertake. Is that kind of a good sum up? If I'm
Yes.
doing it in 30 seconds or
Yes,
less?
we agree. That's a correct summary.
So even if we wanted to address any of these issues in a more vigorous, result-oriented way, that's not before us today.
Correct.
Okay. Just wanted to make that clear.
Absolutely on point what the chair just spoke. The only matters I see it before us today is this approval for the transfer of interest, and that sorts out the issues between the three partners. Whatever comes down the road will come down the road. So I'm prepared to support this application.
Unless there's any other discussion, if it's right for, I believe Commissioner Solis Rainey is going to make a motion.
Yes, thank you. I move for approval of restricted item number 2 is read into the, I'm sorry.
Number 1.
1. I had already flipped. Restricted item number 1 is read into the record and recommended by the Game Control Board.
Any discussion on the motion? Excuse me. There being none, all in favor, say aye.
Aye.
And there are none opposed. The record should reflect Commissioner Kiekefer did not participate in the discussion or recusal on this matter for the last time.
He didn't vote for him again. But I would like to thank Agent Katie Finlinson and Carl Hoffman, the head of the division. We recognize this was a difficult issue that had to be addressed by the board and by Mr. Chemerinsky and Mr. Kaladi and Mr. Moskov as well. So we thank them all for their assistance, patience, and allowing us to provide the information they needed. Thank you.
Thank you.
Thank you.
Madam Secretary, please read in restricted number 2.
Restricted number 2 is the application of the BLC Group, Inc., doing business as Legends Grill Sports and Spirits for a restricted gaming license. It is also the applications of Leon Kaufman and Dylan Kelly Gump for licensure as an officer, director, and/or shareholder. Lastly, it is the application of the BLC Group, Inc. 401k plan as a holding company and for findings of suitability of Leon Kaufman and Dylan Kelly Gump as trustees and beneficiaries as noted on the agenda. The recommendation of the Gaming Control Board is for approval with conditions as noted on the agenda.
Good morning, Commissioner Dylan Kelly Gump for the record. Leon Kaufman, good morning, or good afternoon now. Yeah.
Good afternoon. You can hear us okay?
Yeah.
Okay, great. Did you have any affirmative presentation you wish to make?
We can read what we had prepared for the
That's
board.
great.
Yep, absolutely. So in from the fourth quarter of 2018 until the first quarter of 2020, over that time, we were paying back some hard loans that we had taken out, which has been reflected in our previous 2-year temporary applications, and slowly trying to pay those back. It became hard for us to we couldn't cover obviously all our expenses, and one of the things that we looked at was we just stopped paying our payroll taxes because it was just an expense, and our intention was to obviously pay them back as soon as we could. It became more and more untenable, and as we went into 2020, obviously with COVID, it became very hard.
Would you do me a favor? Excuse me.
Yep.
Excuse
I'm
me.
sorry.
Could you speak a little closer to the microphone for us?
Absolutely. I apologize.
Perfect. Thank you.
You bet. And when it got to a point we were ready to start paying it back, we were advised that we should get somebody to help us do that and create a payment plan, which we did, and we've been making that payment plan to date, and we haven't missed any of those. When we were able to pay them back after 2020, we haven't missed any payroll taxes since then, and we just do have another update. Some good news for us. We were just approved for an ERT tax credit, and it's our understanding that the remaining balance that's left on there will be automatically removed because it is a lien from the portions of that tax credit. Basically, it's a tax credit for keeping employees employed during the pandemic, and yeah, so that's going to wipe out the rest of our lien. So that was just an update that we got just 2 days ago.
You said 2 days ago?
Yeah. Yep. We applied for the ERT tax credit last month. We just got updated. So.
Okay, so I'm going to open it up to questions of my colleagues, unless you have anything else you wanted to add before I do that.
No.
And when either one of you answer the questions, I would really appreciate it if you stay really close to the microphone because it was very hard to hear you when you're 6 inches away, okay? Sorry about
You
that.
bet. No problem.
Okay.
I don't have any questions.
Commissioner Keykeeper has none. Commissioner Cohen?
No question.
Commissioner Brown?
Thank you for appearing today and being here with us this afternoon. Just a quick question about the hard money loan. Was it collateralized? Did it collateralize was it securing all of the collateral of the company, or was it an unsecured loan?
No, it was an unsecured loan.
Okay. And what was the interest rate on that?
Oh, 40%. It was awful. It was a hard
Hard
learning lesson for us. 40% was a bad loan, a very large lesson for us, but we weren't in business
40?
before that. Yeah.
Okay. Okay. I go ahead.
I was just saying the company that did it is no longer in business. They were in the state of New York, where had to stop doing that. Basically, they can't. Those loans are predatory now, and they're not allowed to. So.
Thank you. That helps me understand why you made it a priority to pay back that very high interest rate on that loan. And I understand and appreciate you made a business decision to repay that and to keep the 17 employees working instead of shutting it down because you had that decision to make. But I hope that you've learned your lesson and you don't take those types of loans because they can be very detrimental to the business.
Never have, never will again.
But I have no areas of I have no areas of concern. Did you do appreciate the conditions that were recommended by the board, and do you have any issues with those?
Not at all. We're very aware of them.
I have no further questions and prepared to make a motion if the chair requests.
Sir, excuse me. Did you provide that information that you got 2 days ago to our investigation staff?
No, we have not. We
Could you
can
do that, please?
absolutely. I'll send that to Agent Lombardo as we leave here.
Okay, thank you.
Absolutely.
If there's no additional questions or comments, and I think you said you would be.
Yes, Chair. I move for approval of restricted item number 2 as recommended by the Gaming Control Board and is read into the record by Madam Secretary.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
And any opposed? There are none opposed. Thank you.
Thank you.
Please.
Happy holidays, you guys.
Don't forget to send that in, please.
Do it right now. Do it right.
Thank you. Okay, we are moving to. Madam Secretary, please read in restricted number 4.
Restricted number 4 is the application of Texas Melts LLC doing business as L2 Texas Barbecue for a restricted gaming license. It is also the applications of Lawrence Lerner, Rochelle Berkeley, and John Ball Jr. for licensure as a member and or manager. The recommendation of the Gaming Control Board is for approval with conditions as noted on the agenda.
Good afternoon.
Good afternoon.
How are you?
We're both doing very well. Thank you.
Thank you for your patience. How would you like to start?
Our attorneys.
I'd like to start if that's all right.
Yes.
Good morning, Madam Chair, Commissioners, Madam Secretary, Jennifer Gaynor from J. Gaynor Law, here on behalf of my client, Texas Melts LLC, DBA Texas Barbecue. First, I'd like to thank you for allowing me to appear via video. I am here in Port Macquarie, New South Wales, Australia. And with you live are Dr. Larry Lerner and Representative Shelley Berkeley from Texas Melts. As discussed in the board hearing, this is Representative Berkeley's first gaming license, while Dr. Lerner and their third partner, John Ball, have long experience in the industry. Representative Berkeley will be a passive partner, while operations will be managed primarily by Dr. Lerner, Mr. Ball, as well as their key employee who has also come forward for finding of suitability. In addition, they will have a slot route operator, and that participation agreement has been provided to the board. I will let Representative Berkeley and Dr. Lerner introduce themselves, and then they will be available for any questions you may have. Thank you.
Thank you.
Madam Chairman, and to you and through you to the rest of the board, my name is Shelley Berkeley, and it's a pleasure to appear before you today.
I'm Larry Lerner. We're happy to be here and answer any questions.
So the investigation, kind of like an FBI background.
Kind of.
Speaking from personal experience.
Yes.
Unless you had an affirmative presentation beyond, I think your counsel just said she was offering you to answer questions. So at this time, I guess I would start with Commissioner Brown. Do you have any questions?
No questions. Just wanted to welcome you and thank you for your years of service to the state of Nevada. The only confirmation I need from you is that you've already signed up for the online class for the regulatory compliance seminar.
I've already completed it.
Well, excellent. I
Thank you.
expect nothing less from you.
Thank you very much.
I have no areas of concern, and it's a pleasure to see you here today.
Thank you. You too.
My major area of concern is that you won't have any direct involvement in the day-to-day operations. That's the loss for.
Well, does eating barbecue brisket have anything to do with direct control or direct involvement?
I'll take it. That's good enough for me. I
then I will.
No areas of concern. I've known Shelley and Larry for many, many moons, and I'm happy to welcome you into the industry.
Thank you.
Thank you and welcome. I also don't have any areas of concern. I appreciate you being here. I did have a question for Dr. Lerner. You are going to be overseeing the property?
Yes.
Okay. How do you split your time? I know you're still practicing medicine.
I work
as well.
about half time in medicine now.
Okay.
So I have time to do this. This is
great.
With my transition.
Why barbecue?
Just developed that way. Yeah, my partner, my chef is a fully trained barbecue chef. He was in Dallas for 10 years. And it seemed to be a niche market that could be
Well,
worked.
perfect. I'm excited. It's not too far from me, so I will definitely try it out.
Thank you. We look
Thank you
forward to
again for
seeing
being
you.
here.
Yeah, it's a quarter to one. When we're talking about barbecue.
How's business?
Slow.
Commissioner Keycapper, do you have anything? Okay, well, obviously, I support your application and appreciate your patience today. It's been a long meeting so far, so
I spend most of my days in meetings very similar to this one, so
you can relate.
not a problem. Yes, indeed.
All right, so at this time, do you have a motion?
Go
ahead, go ahead.
I'm happy to make, or I move for approval of restricted item number 4 as read into the record by Madam Secretary and as recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
And there are none opposed. Thank you.
Thank you.
Congratulations.
Wish you the best.
Yes, good luck.
Thank you.
Thank
It's
you.
best brisket in town. But if I could wish you a happy Hanukkah and a very Merry Christmas to everybody else. And best of luck to you in your new endeavor. And I thank you very much for your kindness and courtesy today.
Thank you.
Thank you so much.
Have a good day.
Thank you.
Thank you, Jennifer.
Thank you.
She said Ms. Gaynor.
I just said thank you, Miss Gaynor.
Oh, yes, thank you. Oh, and I also want to thank Agent Jasmine Jeffries for working with us on this item. She's been great.
Thank you. Madam Secretary, could you please read in restricted number 5?
Restricted number 5 is the application of Yeshna LLC to receive a percentage of gaming revenue from Sartini Gaming LLC doing business at 7-Eleven store number 38994. It is also the application of Farhud Faruqi for licensure as a member and manager. The recommendation of the Gaming Control Board is for approval.
Thank you, Steve.
People are trying not to pass out, I guess.
Good afternoon, Madam Chair, members of the commission, Madam Secretary Jeff Donato of Argentum here with the applicant, Mr. Faruqi. We did give a presentation at the board. If you'd like for us to give that again, we'd be able to do that, or we can go right to questions if you would like, whatever you prefer.
Excuse me, I do not need a presentation, but I will defer to any of my colleagues who would request one at this time. Otherwise, we can go into questions. It appears that we can go into questions. Thank you. I'll start on my right this time. Do we have any questions, Commissioner Solis Rainey?
I do not have any questions. Thank you.
I do not have any questions. Thank you.
Commissioner Cohen?
No questions.
Commissioner Brown?
I have nothing. It's a clean record and no areas of concern. Thank you for waiting today so we could meet you in person.
Thank you very much.
Yes, we do appreciate that, and it is nice to meet you. I have no areas of concern, and I think it is ripe for a motion at this time.
Chair, I move for approval of restricted item number 5 as recommended by the Gaming Control Board and read into the record by Madam Secretary.
I would just note the investigative report, if you take off the cover page, is maybe if you compressed it up, it's really maybe a page. So that speaks to your clean background. So with that said, there any other discussion on the motion? There being none, all in favor say aye. Aye. And there are none opposed. Thank you very much.
Thank you. I want to thank Agent Peters for all his hard work during the investigation and wish everybody happy holidays.
Thank you. You too. Thank
Just wanted to say thank you very much for this and happy holidays. Thank you.
Thank you.
Thank you. All right, Madam Secretary, could you please read in our next item?
Next for your consideration is one gaming employee registration appeal pursuant to Nevada Gaming Commission Regulation 5.109, which is a correction from the agenda. That item is AVL Benezra, case number 2012-7588L.
Thank you.
Good morning,
Hello. Could you state your name for the record?
Aviel Benezra.
Okay, so this is your opportunity to address the commission regarding this item. We're just getting to our notes, so give us 1 second. And when you're ready.
Well, it's been over 10 years since I've been here. Back in 2012, I'm sure you're aware of the incident that I was involved in. After that incident occurred, I did lose my gaming registration. I did lose my job. I did lose a place to live. It was a very difficult time. I was 23 years old. I am 34 years old now. After that incident, I had to adjust. I began working at 7-Elevens, Green Valley Groceries, all types of gas stations, Rebel Oil, and in multiple locations. It was still a difficult time. I was homeless for about 9 months. I was living in my own car. I ended up having 2 gas station jobs at the same time in 2014. In 2014, I ended up losing both jobs within a 2-week time span. And I was ready to, pretty much give up, move somewhere else, start a new life. Instead, I just kept chugging along. And August 11th, 2015, I received an opportunity to work at Universal Protection Service. And that's when I entered the security industry. I was titled a rover for approximately 2.5 years. I was trained at 29 different properties in 1 year, anywhere from HOAs, apartment complexes, distribution centers, warehouses, you name it, I was there. I have records of everywhere I've ever worked since 2015, every day, all the hours and locations. In 2017, I ended up working at one position at Blue Green Vacations. I was working at a timeshare. I took a permanent position because I had my first child. After Blue Green Vacations, I resigned and I continued working for Hilton Grand Vacations, where my security experience, I feel, shot rocketed. And I ended up doing from 2017 to 2019, I did 101 incidences in 1 year, domestic violences, physical altercations, hotel property damage, guest injuries, team member injuries. I've dealt with an assisted HPD, Las Vegas Police Department, American Medical Response, Clark County Fire Department. There was always somebody involved in one of these incidences. I carried cuffs. I had a badge, unit number 8. I carried an investigation kit with me everywhere I went with a first aid and AED medical bag. I took an exam in 2017 where I got my American Hotel and Lodging Association certificate. I kept progressing as much as I could while everybody there was just for a security officer job. I made it into my own career. I went back to school, got my high school diploma. I took many courses such as, bloodborne pathogens, hazardous communications, customer service skills. I was enrolled in a lot of courses every month. I took verbal judo. I took active shooter training. I did my advanced report writing. I learned all about de-escalating incidences. Excuse me. I became very detailed in everything that I did. Everything that I've ever learned, I've always kept right here in this book. It took a while to have others trust me. Working in the security industry, I was in charge of safes, in charge of money, in all kinds of places. In 2019, I was promoted to a control room operator, and that's when I decided to progress in dispatching. So I was in charge of a team of 10 plus officers. I'm used to dispatching different officers to different incidences happening all at once. I was able to multitask like no other. In 2020, I resigned from Hilton Grand Vacations. I started working as a patrol supervisor for St. Moritz Security Services, and that was located in Seven Hills. I was in charge of 3 gatehouses. That's when I proceeded in programs and I received my certified security officer, supervisor, and manager certificate from Private Security Professionals of America. After that, I was accepted in a job opportunity for Securitas Security Services as a SOC operator for Aristocrat Technologies. That's where I had the pleasure in meeting Trevor Jake Broker. I was trusted with millions of dollars worth of merchandise. I was around gaming machines all the time. I watched other states in other states in the United States that had distribution centers and warehouses with all the gaming information, technologies, systems. I've learned so many softwares and programs. I can go on and on. After that, I received an opportunity as a SOC operator at a Google data center. And now I'm in charge of a team of 25 plus officers. And I watch over 1,400 cameras a day. I answer 400 alarms within an 8-hour time span. I learned so much and made my security experience to the next level, to my belief. I know that I'm more than capable of working in a gaming industry. I've had many people trust me out with payouts, jackpots, just handling money again. And I feel that I've progressed in many ways. And I never gave up. I've always enabled in a job. I've always kept working. You know, I never left Las Vegas. I always just stayed here. I have a lovely family now with 2 daughters, and I'm still trying to progress. I've had many job opportunities that I'm unable to accept because I don't have my gaming registration and I'm not eligible for it. Vicinities that have gaming machines, but I have no interactions with them whatsoever. But it still prevents me from working in that area. I've learned all my metro codes, my security codes, my phonetics, my alarm abbreviations. I know how to detect, I know how to prevent incidents from happening. I know when bad is about to come. And I just really tried my hardest to keep going. And, like I said, it's been over 10 years since I've been here and I have not given up. I know that I had my gaming hearing not too long ago. I believe I was denied with the objection to my gaming registration due to I feel was a miscommunication of transparency regarding my trespass from station casinos. Let the record state that since 2012, I have not been in a station casino since. I've been very respectful in keeping off their property. Every time family wants to go out, go to a restaurant, maybe located inside one of these casinos, tell them no. I deny it. I refuse it. I don't want to go until I have approval. I have everybody else trusting me with handling money and being that person to make that judgment call on various situations. And I'm here today to ask for your trust back and to let me, proceed and hopefully receiving more job opportunities with higher pay.
So I don't know if you know that we, as a commission, get the full record of the proceeding below. So I don't want to leave it unsaid that our record starts with, the September 27, 2022 letter of objection of the control board and goes all the way through hearings, certified letters, every document below, including but not limited to, the lists and the information that you presented. So I usually would say that at the beginning, but we've been going like 3 hours nonstop, and I neglected to mention that for your comfort level that we have all of that, just so you know. Doesn't really mean anything, but I just wanted you to know that we have it all. And now, unless you have anything additional to add, I will open it up to questions of my fellow commissioners.
I feel that I misunderstood the question on the application regarding the trespass when it asked if I was aware that I was trespassed from a property. I put NA because for the reason that I don't remember being read a trespass warning at the time of the incident, but I do remember calling out and trying to reach out to the security director to try to get my trespass warning lifted. And that's when I found out all that information.
Okay.
I believe that was in 2014 or 15 when I started working in security.
Okay. I'll start with Commissioner Solis Rainey.
Sure. Thank you, Madam Chair. You've done a lot of education. Has any of that been required by your employer?
No, it was an option.
Okay, because we have a bunch of certificates of completion for the courses that you
Yes.
described. We also had a nice letter of commendation from Hilton Grand Vacations. I
Believe it.
commend you on going back and getting your high school
Yes.
diploma. I know it's difficult to do at an more advanced age, but the fact you did so to me shows your perseverance and your willingness to move yourself ahead. You didn't address the issue in 2017 with the HPD. So if you could maybe just briefly address that from your perspective.
2017 for
That was for the misdemeanor assault.
misdemeanors. Okay. Did you want to know something specific or?
No, given all the training that you've had, what prompted you to go out and
Oh,
interject yourself into this process?
wrong place, wrong time. I shouldn't have just went out there. I should have just stayed inside and mind my own business. Working in security, I was just so curious to see what was going on outside my own home. And it just one thing led to another. It was a verbal argument. Both parties became verbally combative. There was no touching involved. There was not a fingertip laid on anybody.
Okay.
And I just let HPD do their jobs.
Okay.
Didn't interfere with nothing.
And you don't have any problem working with HPD now because I believe
Oh,
you
of course not.
indicated.
Oh, of course not. I've assisted HPD in many cases. Like I said, when I was working at Hilton, I did all those incidences, and every one of them either involved AMR, CCFD, or Metro. So I was always willing to, I learned to have a lot of respect for the police department from where I was back over 10 years ago.
Okay. I don't have any other questions for you. I would pass to.
I just had a couple of quick questions, sir.
Yes.
Since this altercation in 2012, or excuse me, 2017, have you had any other incidents involving any of the law enforcement agencies in the state of Nevada or any other
No.
jurisdiction?
No, sir.
Assuming this commission were to either modify or reverse the findings regarding your work card, what is it you want to do in the gaming industry?
I want to catch my old self cheating on that table. I want to be able to be that person to make those calls. If I'm able to learn table games and stuff like that, and I get a job opportunity doing that, I want to be able to do it. I'm more than capable. I did have an opportunity to work for Tao. I believe they do have gaming machines in their vicinity, but it wouldn't be pertaining to the position that I would be filling in as a surveillance operator.
Thank you, sir.
Yes, sir.
Commissioner Brown?
Could you provide me with some more insight relating to your disagreements with the June 2012 arrest report? That seems to be a bone of contention.
June 20.
Yeah, the arrest report for June 2012. I thought that you had disagreements with that arrest report. Can you explain to me what your disagreements are with that report?
maybe back then I would have had disagreements, but not, I can't think of what they were. It was just so long ago.
Okay, I'm just,
I think it maybe has something to do with the amount of alcohol that I've obtained that night. Maybe my decision-making skills were very poor. So, um, I only remember a few things on and off from that day. I was just very highly intoxicated.
did you disagree with anything at any time in the June 2012 arrest report?
I was overserved. I felt like I was overserved.
Can you be more specific?
I remember not even finishing halfway with my alcoholic beverage, and the waitress would bring me a brand new one. I felt like maybe I had way too much, and it was way noticeable. But I don't feel like anybody maybe tried to help me understand what was going on at the time that it was actually occurring. That's about it. I accept everything now. I moved on. Just want to do good and progress for the better.
No, thank you. I find that you have appeared to have made meaningful efforts to improve yourself and educate yourself and stay out of trouble. I don't think there's been any incident other than you getting involved in the altercation with the teenagers.
Yes.
Other than that, and the DUI right after the initial arrest for the
Tough times. Yeah, right after
Yeah,
the arrest,
yeah,
I was
just months
going
after.
through a hard time, and I ended up getting a DUI as well. So,
Yeah.
yes.
I don't have any other questions for you.
Oh, okay.
Thank you.
Commissioner Keycapper? Anything?
I don't have anything. Thank you. Appreciate
Sir, the reason I think, I can't speak for others, but I can speak for myself. If you've been here all morning, you understand the significance that this commission and our investigators and the board put on truthfulness, right?
Yes.
And I think for someone like you, truthfulness is beyond measure important. And what I mean by that is for someone who's going to want to be in security in casinos and work hand in hand with the power that comes with being able to tell a police officer something. In our system, one witness worthy of belief is sufficient for the truth of any fact. That's how you have cases go to trial on a he said, she said, or a he said, or a they said, right?
Yes.
So people can take what you say and you can ostensibly drive a prosecution. You can have significant impact on someone's future just because you're a security guard at a casino, and you're held to a higher standard for a reason, because police will rely on you when you convey information to them, right? And so there's this kind of circular. I guess my issue is I don't sit here today and think you're going to grab a chip and run away or add money to a bet. Okay, that's not my concern. My concern, and I think you saw a little bit if you were here earlier today, I have significant issues with transparency.
Yes.
And the whole misunderstanding thing doesn't work for me.
Okay.
I read this entire record. I have respect for what you've done with your life. And I'm not suggesting that, that there isn't a difficult call here, because as I'm told by the, when I review this, usually we're doing these work cards and it's a year. Come back in a year, and this one's a 5-year, and that makes it harder, right?
Yes.
But at the end of the day, for me, that's the deal breaker. But that being said, there's 5 of us, so keep your fingers crossed, because at this point, someone's going to make a motion, I think.
I understand.
Okay. Unless no one's going to make a motion. Is there any additional discussion, or is someone willing to make a motion? I think
I will, and go ahead. Just give me a second.
No, that's fine.
Okay. I'm moved to, I have a lot of respect for the investigators process, but in this case, that respect is overridden by the significant efforts that you've taken, and also just the record, the education that you've received, the commendation from Hilton. 5 years to me is just, it's too long, and I think you've earned the right to be given a chance. I would move for is it overruling? I can't find the language.
I think so.
Yeah, I would move to reverse the board's objection to Mr. Ben Ezra's registration as a gaming employee, conditioned upon him having, maintaining a clean record for the next 2 years. I mean, that puts you last incident was in 2017. I think that's pretty far removed. If that would be my motion at this point.
So to clarify the condition, when you say if something were to come to light, or what are you referring
He
to?
would need to report any contact that he had, any negative contact with law enforcement if, there's any incidents
Going forward or in the last 2 years?
going forward for the next 2 years.
Oh, next 2 years. I misunderstood what you said. I apologize. I thought she
Like
said
probation.
last.
Like a limited license, but limited registration. If it makes others more comfortable, I guess the motion's on the table, so I have to let it be, right?
That works.
Okay.
Yes.
All right, discussion on the motion.
I support the reversal of the board's objection to your registration, but this is your opportunity to prove that you are entitled to be where you are.
Yes.
So make us proud and make yourself proud and make your family proud. And I think 2 years is a good amount of time. Otherwise, we have to ask you to come back in 5 years. And based on what you've done, I'm comfortable with that.
Any other discussion on the motion? All right, all in favor of the motion, say aye.
Aye.
And I am opposed, for the record. Good luck.
Thank you very much. I really appreciate your time and happy holidays to everyone.
Thank you. Okay, Madam Secretary, next agenda item, please.
You have one regulation agenda item regarding proposed amendments to Nevada Gaming Commission Regulation 5 as noted on the agenda.
Good afternoon, Madam Chair, members of the commission, Madam Secretary. For the record, I'm Ed McGaw with the Nevada Attorney General's Office, appearing on behalf of the Nevada Gaming Control Board in this matter. Before you is a set of regulations addressing cybersecurity recommended by the board for adoption. The goal of these regulations is to provide a general framework for certain licensees to follow to protect their computer systems and the information stored thereon from the threat of cyber attacks. The draft before you today is dated October 17th, 2022, and incorporates many of the changes requested by the industry since the original draft was released at the end of August. The modifications made to the original draft are color-coded in the current draft, so you can track where we've made changes. This draft supersedes all previous drafts. The board did hold a workshop on this regulation back in September 26th, 2022. With me here today to answer any questions the commission has are the chief of the board's technology division, the chief of the board's audit division, and the chief of the board's tax and license division. With the chair's permission, I could provide a quick walkthrough of the regulation.
Please.
Okay. Second here. Starting with subsection 1, this provides a general policy statement regarding the reasons for the regulation. It references the general policy of the state found in NRS 463.0129, as well as NRS Chapter 603A. That section addresses security of information. It is purposely kept broad to state that this is what is expected of all licensees, all gaming businesses that fall under the board and commission's jurisdiction. Subsection 2 provides the definitions of certain terms used in the regulation. It also defines who must comply with the specific requirements.
Can I interrupt you for a second? This is the 10/17/22. Just want to make sure I'm I get so much material. I just want
Okay.
to make sure I have the right draft, right?
Did I read the wrong date?
No, you didn't. I
Oh.
just want to make sure our date is. Okay, okay. Sorry to interrupt. Please continue. You are in section 2, I think.
Yes.
Thank you.
Moving on to subsection 3, this provides a covered entity. The regulation set up that certain entities have to meet additional requirements, and those are referred to as covered entities. The board wanted to keep it focused on those that would have the highest cybersecurity risks or the risk of damage should a cyber attack occur. It's further restricted that certain requirements would only apply to Group 1 licensees who are covered entities. Again, these would be the larger properties, more exposure, more risk of harm. So that is the general structure of the regulation. Subsection 3 provides what covered entities must perform, that covered entities must perform an initial risk assessment and continue to monitor and evaluate cybersecurity risks on an ongoing basis. This requirement is intended to allow all covered entities discretion to determine what procedures are appropriate. The board purposely does not dictate what specific procedures must be implemented. It is a business judgment call by the individual licensees or the covered entities. It should be noted the language in subsection 3 was modified after the board's workshop. One change makes it less rigid based on comments received from the industry. Another change was to clarify that an affiliate or a third party may be used to perform the assessment and monitoring. Also, the provisions that allowed the chair of the board to approve modified timetables was removed as it was deemed unnecessary given the modifications throughout the rest of the draft. Subsection 4 sets out what a covered entity must do in case of a material cyber attack. These are the key requirements. One is within 72 hours, it must notify the board of the attack. It should be noted here that based on industry comments and suggestions, the requirement that a covered entity affirmatively provide the board with certain information was removed, and instead it was replaced by a notice upon request. So if the board requests information about the cyber attack, the licensee will comply and provide that information. This was done for security reasons as well as to the dialogue between the licensee and the board on the issue. In addition, the covered entity must conduct a thorough investigation of what happened and provide the board with notice of the completion of that investigation and provide the board access to those results. And lastly, the provision provides that the licensees, covered entities provide the board with notice and access to any reports provided by an outside entity regarding the cyber attack. So if they bring in an outside entity, they must provide the board with information of that and provide the board those records upon request. Moving on to subsection 5, this provides some additional procedures that must be performed by covered entities that are classified as Group 1 licensees. These, again, are the larger properties. These include the requirement to designate a qualified person responsible for overseeing compliance with this regulation. There have been a couple of public comments regarding who would be considered qualified to fill this position. The board purposely kept this open, to give licensees broad authority to determine who in their organization would be best suited for that role. But the person would have to be someone who was knowledgeable enough with information systems to adequately perform those tasks listed. This subsection also includes a requirement that internal audit or an independent cybersecurity expert, verify compliance with the best practices implemented by the licensee based on the risk assessment, and that this review be performed at least once a year. There's also a requirement that an independent accountant or cybersecurity expert perform an annual review of the best practices implemented by the covered entity to ensure they're in compliance. Subsection 6 sets out the record-keeping requirements relating to the regulation. The original subsection 7, which required submission of an annual attestation, of compliance with the requirements of the regulation was removed. That was deemed unnecessary. They are required by law to comply. There's no need for them to submit an attestation. The new subsection 7, which was formerly subsection 8, provides that a failure to comply with the requirements of this regulation constitutes an unsuitable method of operation. The proposed effective date of these regulations is January 1st, 2023, which gives them a year to come into compliance. Or wait, no, sorry, excuse me, let me back up a little bit. The regs would become effective January 1st, 2023, with the explicit provision that covered entities have until the end of 2023 to comply with the requirements of subsection 3, which is the annual assessment and all those procedures. So they would have a year to come in compliance. With that, I conclude my presentation and would be happy to answer any questions, or if you have any questions of staff, they'd be happy to answer as well. Thank you.
I appreciate the presentation. This is important stuff and a lot went into it. So I just appreciate you going through it. I'm going to open it up to my colleagues for any comments or questions.
I just had a couple of comments. I saw a number of letters, to the board addressing this, South Point, AGM, et cetera. I see Virginia Valentine in the audience. Did the NRA adopt a neutral position to this, or not to put you on the spot?
But you're on the spot.
On the spot. So good afternoon, commission members, Madam Chair, Madam Secretary. My name is Virginia Valentine with Nevada Resort Association, for the record. The Nevada Resort Association did not submit any written comments. We did attend a couple of meetings with the Chief of Audit and Enforcement. We had a number of members, in particular IT staff, people attend with us. They ask a lot of questions. Some of what you see in this draft is reflective of those changes that we requested. At the end, I think if there were additional comments that weren't addressed, then members probably chose to express those on their own, independent of the association. So I have no further comments today.
Very good. Thank you very much.
Thank you.
Commissioner, are you going to take other comment?
Yes.
Okay, and then would now be appropriate?
Yes, please.
Great. Madam Chair, members of the commission, members and staff of the board, Dan Reeser with Fenimore on behalf of the AGM, the Association of Gaming Equipment Manufacturers, and with me is Darren Dorsey, the Executive Secretary. We just wanted to place on the record that we submitted written comments on November 21st, 2022. Those comments were submitted after former Chair Gibson came to the association and asked for us to review the regulation and provide any input we thought appropriate to the commission. And so we have done that, and we are very happy to answer any questions about our comment letter, but we'll just stand on the comment letter and not review it with you unless there's any specific questions.
I think that's the last comment letter in our packet of materials.
It is.
So I will ask my colleagues, since we have Mr. Reeser here, if you want to inquire of his November 21st, 2022 comment letter before we maybe go back over thoughts, questions.
I just have a general question, and this is open to anybody who would like to respond. Under section 4A, the revised proposed language relates to a 72-hour notice provision. Was there any dialogue in terms of making that shorter or longer? Is 72 hours too long in terms of notifying the board so that the board can notify other gaming establishments here?
So on behalf of AGM, I'll just simply comment. We did not have any concerns with the 72 hours. It is not atypical. Representing financial institutions and public utilities, there are similar regulations. Public utilities have a much shorter time period because of a cyber attack may be to a critical function, but the 72 hours is pretty commensurate with the banking industry.
Thank you.
And Commissioner, if I could speak to the board's choice of 72 hours, We just wanted to pick a number that would give them adequate time to gather their people, get an assessment of what happened, and provide us with a report to us. Certainly doesn't mean they can wait 72 hours before they respond or react to the cybersecurity attack. It's purely to notify us. And we felt that was limited enough time that the board, if it had broader effects or there was a risk to the industry as a whole, the board could take needed measures or the necessary measures to try to mitigate as much of the damage to other participants in the industry.
Thank you for that clarification.
The only other additional comment we would have are two in number. It's probably obvious to you that this is an operator's regulation, not a manufacturer or distributor's regulation. And the one of the issues that did arise was many manufacturers have slot route operators licenses, which would be captured here. But those are only for the purposes of not operating a slot route operation, with one exception I can think of, IGT at the airport in Reno, but actually just to receive percentage revenue. And we did, the manufacturers wanted to make sure that that was clear on the record. And then this is both an AGEM comment and just a comment from experience. The one major issue I have with the regulation is that unlike many other regulations, it has no waiver provision. So if there is an impossibility to perform some aspect of this within some time period, you're not giving the chair of the board the ability to accommodate that issue whatsoever. This is a bright line set of regulations, and there's not a safety valve. And we have, in the last at least 15 years, been putting safety valves in most regulations. So that's the only other major policy issue I see.
So there's no safety valve for the safety valve.
Pardon?
I said there's no safety valve for the safety valve.
Correct.
Okay.
Could you give us an example of implementation of that waiver in this situation? Just an example.
Certainly. The one that immediately comes to mind is if you're many major public companies have other federal regulations that would require them to do cybersecurity reviews within certain time periods. Those certain time periods could be such that a periodic review is under review by the public company, but not going to be done by December 2023, but instead by the next time that the 10K is going to be filed in April of the following year. That's the suggestion that they should have to do two cybersecurity reports, one for the board and then one for other purposes, is probably an unnecessary expense, and I could see a basis for use of the safety valve there.
Thank you.
Why don't we start with your response to that?
Okay, we'll start with the waiver response. The board did evaluate that, and we determined that these are written broad enough that it wasn't really necessary to put something like that in the reg. Certainly it's the commission's discretion to put it in, but we felt that the way this is written now, it gives so much leeway to licensees and how they interpret it, how they apply it, that we didn't feel it was necessary to provide that waiver provision. And as far as Mr. Reeser's first comment about slot route operators, we had covered that in our previous draft. If you look under the definition of covered entity, it means an entity required to comply with everything. But the first subsection says holder of a non-restricted license, that's defined in our NRS 463.017. And then it goes on to say who deals, operates, carries on, or conducts or maintains or exposes for play any game as defined in 463.0152. That language comes from the definition of gaming. So unless they're offering gaming, exposing it to the public for play, the intention was that unless they do that, those would be the only non-restricted licensees that would have to comply. So just to let you know, we did address that.
And what about what consideration was given to that final point, which is, we have federal, we might have a process in play, and that's a whole different expense and time frame.
And that kind of goes back to when we removed the specific reporting requirements, because we understood that they would well, the front end of it would be that they could be working with the FBI or another agency to investigate the cybersecurity, and they may not be able to provide the board after the 72 hours with information. It may be much later that they get that information to us. So that's why we set it up to be, once the investigation's complete, then you give the board access unless there's something.
I heard his hypo differently, which
Yeah.
is 1 year, but
Mhm.
yet my federal plan is 18 months. And therefore I'm doing it for the board in a year and I'm doing it for the feds in 18 months. Am I misinterpreting what you said?
No, and I apologize. I was,
I'm
and
gonna segue and I cut you off.
no,
Okay,
I
but
meant to
it
address that
happens.
as well. Yeah, on that point, if they do want some sort of waiver like that, we would ask that it be that specific or something as far as overlapping or limited. But I guess
But
it would
there's
be up to the, I'm sorry.
no written waiver, but you believe the flex is inherent in the language.
Yeah, but what member or Mr. Reeser brings up is something that I hadn't considered before. I don't know if Chief Barbie has something to add to that.
I don't, thank you. I just got the look and I thought I needed to get up here to assist Mr. McGaugh.
That's good.
Chief Barbie, do you have any, I guess, opinion on having a specific waiver provision?
Good afternoon. My name is Jim Barbie. I'm with the Technology Division. Commissioner, I don't know that a waiver provision, and especially such a general waiver provision, is appropriate in this case. The provisions of this regulation are somewhat general, not to the point of being vague, but they're general enough that the licensee, for example, doing a risk assessment, there's nothing really to waive there with a risk assessment. For the covered entities and having an individual being responsible, I'm not certain what we would waive there. For notification requirements of incidents occurring, I'm not certain what we could waive there. In the incident or the case that Mr. Reeser suggests, that the annual review process, while I do greatly appreciate that entities may have other requirements, federal requirements, and we try not to be encumbrance upon them in being in conflict with those, our requirement is annually. We have annual requirements that this would coincide with, for example, annual requirements for certain audit functions and whatnot. And that's regardless of whatever their requirements might be, let's say for SOX or PCI or whatnot. So these were requirements that we considered were appropriate for the Gaming Control Board. I do appreciate it and acknowledge Mr. Reeser's comments that there may be other requirements for other agencies. And if there was consideration to be made for a waiver, I would agree with Mr. McGaugh that the considerations for a waiver be specific for something along those lines and not a general waiver provision for the regulation as a whole.
Thank you for addressing that. I just thought it was important to put that in the record. The regulations seem broad enough to me that I understand not having it. At the same time, I wanted to get your input because I don't have strong opposition to adding it.
So if it passes as is, Mr. Reeser just needs a transcript of today's proceedings.
And if I may add to what Chief Barbie was saying, they are already required as the Group 1 to have an annual internal audit and an annual external audit. The concept or the idea behind it was that these procedures would be tagged on to those already required audit requirements. So it wasn't meant to be a new thing, but maybe additional work by the auditors. And if they wanted to hire a cybersecurity, that's their choice as well.
Thank you.
Or cybersecurity experts, sorry.
And it was my understanding that that's how some licensees are handling it now anyways. So I don't think it creates a significant burden. And to the extent there is that overlap, I think they can always piggyback on it and the expense wouldn't be significant.
And also these are audits to ensure that they've complied with the requirements. It's not that they perform a risk assessment on its own. They're just checking to verify that they have gone through the reg and they have complied.
Are there any additional comments or questions? Okay, there being none, it appears that this matter is ripe for a motion. So,
Chair Tagliati, I would move for like, proposed amendment to Nevada regulation, to the regulation for the adoption of this regulation with a draft date of October 17th, 2022 and with an effective date of January 1, 2023.
Discussion on the motion? All in favor, say aye.
Aye.
Aye. And it appears there are none opposed. Thank you.
Thank you very much, Commissioner.
Thank you. Good to
Thank
see you,
you
Mr.
for sticking
Dorsey.
around.
Thank you very much, and we'd like to thank Commissioner Kieficker for his service and for the continuing service you'll be giving the state of Nevada.
I was just going to go there. Before we go to our administrative reports, I would like to thank Commissioner Kiefer for his work on the commission. And I think I speak for all of us when I say we've really enjoyed working with you. You have a very practical, straight shooter approach to things that I really like, and it's been a pleasure. And the magnitude of what you are being entrusted, that job is obviously we're all thankful you're going to be there, and we think you're going to do a great job. And good luck. Yes.
Thank you. I appreciate that, and I certainly have appreciated my brief time on the commission. I did not expect it to be just over a year, but sometimes when you're asked to serve, you got to serve. So I want to say thank you to all of the staff at Gaming Control, the Gaming Control board members, and certainly all of my fellow commissioners for your help and advice and counsel throughout this time. I've learned a lot, and I'm sad to be leaving, but I won't be too far away. Thanks.
Okay. I wanted to, next on our agenda are the administrative reports from the board.
Thank you for that. I'll echo those comments, though. Gonna miss you. For January, we are gonna have a meeting on January 11th, 9 a.m. We're gonna have 4 non-restricteds and 6 restricteds, and then later in the month, we're also gonna have a special agenda meeting the day before the commission meeting. At least that's the intent, and that's gonna be on the 25th, scheduled for 10 a.m.
Thank you. Anything from the Attorney General's office today?
Nothing today, Chair. Thank you.
All right, Madam Secretary, if we could close with our last agenda item, public comments.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters.
I'll first go to Carson City. Anyone present wishing to make a public comment, please step forward to the podium. It appears there are none. Here in Las Vegas, is anyone present to make a public comment? It appears there are none. That will close our public comment section. This concludes the Nevada Gaming Commission meeting for the month of December. We are adjourned.